Together, as we initiate chaos theory guarantees that we'll play like lightning shots sounding like thunder. For every time in the face that it hits us, we're faster. Well, they should know by now what they see. The world keeps trying to shake us, it only wakes us. The pendulum swings, the pendulum swings. It's in a beautiful darkness, only another. It's full steam ahead, full steam ahead. All above the Betty Express, misdirected from the start. It's a runaway train, I come a freight train, I come a freight train. In a beautiful darkness, the Betty Express. In a beautiful darkness.
Okay, you guys. So it looks like we are going to be getting closing arguments today. So this particular witness must have had more testimony that wasn't allowed to be broadcast. Now, I have heard that local news is showing a bit more, and I am going to look at some of their coverage to see if we missed anything while we're waiting for a verdict watch. Now, a little bit of housekeeping, and just to let you know, I have been trying to check Chat GPT, but it looks like when we get the verdict, whatever it turns out to be, victim impact statements might happen at that point. So do be mindful. These impact statements are obviously going to be the pain and collective hurt that all these family members have had to hold in um, since the defense started babbling. So I could imagine that they're going to be incredibly painful just because of the heinousness of the crime and the innocence of, the defendant who or the victim who was lost. But while we are waiting, we will go over the defense's cross of the state's expert. I did watch in the morning to make sure there wasn't anything super objectionable. Um, yeah, and JKD Buck is right. So they're not the easiest parts of trial, but I always do attempt to watch them and have a stream going, have a place where we can watch them together because they're not easy testimony, but I like to honor the loss of the victim's family. And this one has touched us all so incredibly. So I think being able to hear the family side now that they'll be free to give their own story and how this has really impacted them without impacting the case will be nice. But let's hear the defense give their best shot.
Yes.
When the state asked you that whether or not you saw any cocaine use in any of these videos, you said, no, I didn't. Well, let me ask you this. Is it possible that the cocaine use occurred after Tanner had covered the lens with the sticky?
That's what he said in the evaluation to me.
So you said you didn't see it, but is it possible that that's when it occurred?
Sure. Like I said, that's when, in other words, I'm answering you using his self-report.
With regard to the planning of this, Tanner had been on that road before with his truck. Do you recall that?
Yes.
So it's not that, when you said that he had been there before, the way that it came out is that he went there to scout the place as a place to bring a victim. But that's not.
Yes, he knew that this was a secluded area. I know you're trying to talk over yourself, but he warned Athena that there would be bumps. He knew that this place was secluded. He wasn't going to get bothered. If anyone saw a FedEx, van on the side of the road, they wouldn't be too worried about it. He had planned this.
What was going on, was it? He had actually been there because that was the route that FedEx had sent him on to deliver packages.
I'm going to object that for that, Your Honor, in this state.
I'll let him answer it if he can.
Well, he had been on those routes before, but I remember from the investigative records that before he abducted Athena, that he spent some time at that place where he drove back to.
What
So
records?
yes to both.
Yes, if you remember, and since it's kind of my job to remind you guys, one of the digital forensic experts from the FBI, not the one who talked about some of the content of the phone, but basically the locations when they were trying to find a potentially alive Athena. They had coordinated, spots where the van had stopped for a while, and he had stopped at this general location where the assault happened, multiple times for longer periods of time than you would if you were, say, driving your route. If you're driving your route normally, why would you stop in this random area? So, they were able to pinpoint that area as an area to look at, because of the digital data in the very early hours of the case. And this expert has gone through all of the evidence the state has, and he is clearly able to bring up those facts and say, "Well, wait a minute, no, the experts used geofencing and all that stuff to see where he was."
So what records are those?
There were some, it looked to me like FBI records where they were charting his movements based on cell phone pings and towers. It's way over my head.
Did you think to try to find collateral evidence that may have been just his basic route? Or did you just take it at face value and make the assumption that that's why he had stopped there?
I just know that he stopped there before. And like I said before, he told me he'd been on those routes before. So either way, he knew when to tell Athena it's going to get bumpy because he had been there.
But that's not necessarily indicative of planning, is it?
Well, he knows where he's going. In other words, if he didn't know where,
I hate this woman. I know I have said because look, I legitimately dislike this woman on a moral and intellectual level at this moment. But I do want to be fair to her powers as an attorney. And I do know I'm highly emotional about this case because of the innocence and the innocence of the victim and the heinousness of the crime. So I am trying to will myself to have the intellectual, well, rigor that would be giving her another chance at another case to watch another case she's run, but I can't do that right now. It's gonna need to be about a year.
he was going, and it was just impulsive, and he had no idea where he was, then he wouldn't know to forewarn her that it's going to get bumpy.
But again, that is not indicative of planning to abduct a child, is it?
Yeah, I looked at it as part of the abduction. As I stated earlier, the abduction was related to his sexual exploitation of her. That was very clear to me. And how he got there was just how he got there to where it was going to happen.
And that is just your opinion as to why this happened.
It's based on, well, it's not just my opinion. It's based on my training, the grooming behavior that he engaged with her. Per the audio, as soon as he turned off the truck, he went to the back, then take off your clothes, and then from there, it was one after another.
May I approach your honor?
Yes.
Again, as the defense who wants you to feel or wants to engender some kind of mercy from the jury to Tanner, I don't know why you would be going into this. Yes, it's incredibly damning that this witness says that Tanner, in his estimation, as an expert in, people that have these sort of paraphilias and then intersect with law, in his professional opinion, this was motivated by disgusting, perverted, needs. Yes, absolutely. But you guys also be mindful of your mental health. We are going to get to closings. There is an hour limit for both sides. And I have a feeling that the state is going to remain respectful, dignified, and restrained, maybe a little more passionate, maybe a little bit more, this is what happened, this is what we showed you, but still maintaining the dignity and respect that little girl deserves. Athena Presley deserves. I imagine that our mental health warnings are going to be from the defense. I believe the defense is going to pull out all the stops. They are going to be just as annoying as the defense in the Canero trial.
Dr. Rangula, I'm going to hand you what the mark is.
So it's exhibit 312. It's your report. Can you point out in your report where you talk about going on the bumpy road and planning this incident?
Again, ma'am, do we want to talk about the fact that your expert didn't write a report?
I don't remember actually doing that. No.
Okay, can you point out in your report where you talk about grooming?
I think the only thing I talked about was that this event didn't just show up out of nowhere. Again, this is during the guilt innocence phase, so it's different than what we're talking about today.
So planning would not be a part of the guilt innocence phase?
If it relates to the mental condition that he had and he was claiming confusion, then that would counter it, but that's not what he was claiming, so I didn't include it in my report.
So grooming wouldn't be relevant to.
Oh, ma'am, do not make a face to the jury like you are empathetic or like you are Catherine from the trial that, that Megan is following. Oh, hell no. First of all, you have stepped on every one of my damn nerves today, and we haven't even started.
Enough to include in your report?
I mean, I could have added that, sure.
But you chose not to.
Well, maybe I didn't just do it. But yeah, looking at
Your
the.
Honor,
Okay.
non-responsive.
Sustain.
All right.
I want to talk to you lastly about your opinion on future danger. You claim that you feel that Tanner would be a danger in prison because there are female guards. That's
Not
part of it.
as a potential component, yes.
So
How, as a woman, can you not grasp that other smaller women? Look, ma'am, I know you have the physique of a young, strapping Janet Reno, but not all of us are built like a young, strapping Janet Reno. I'm about a foot younger or shorter than Tanner, and for the first time in my life, I am probably at a weight disadvantage with Tanner. And it's a weird place to be in, especially, when I've always felt kind of confident that as a fluffy person, look, I'm not going to get at least kidnapped. But I wouldn't be alone with Tanner. Just because she's built like a defensive lineman from the 1984 Bears, it isn't my fault. Don't get mad at us because you're built like look, it's not my fault that people automatically look to see if you have an Adam's apple, ma'am. It's just the time we live in. It's just the times we live in.
you review the records and you realize that, and you understand that Tanner has not had any disciplinary write-ups in Tarrant County.
I think, yes, that's correct. In his whole cell, he has not been a behavior problem.
And he did not have any disciplinary write-ups in Wise County either, did he?
I think there was only one time where he was put in a restraint chair that he pointed out to me, but other than that, no.
And he was put in a restraint chair because he was inflicting self-harm. Is that your recollection of it?
Vaguely. I don't remember the reason that he explained to me.
So that wasn't really a disciplinary, was it?
It's a form of disciplinary because the people can't just let him do what he's going to do. So they have to discipline him in some way so he won't hurt himself.
But
It's not a form of discipline. It's more of behavior modification.
So he wasn't being aggressive towards anyone when that occurred, was he?
I don't remember that, no.
Now, when you're in a jail, you
Also, ma'am, that jacket is 1 size to 2 sizes too small for you. I shouldn't see the outline of your shoulder pad. I mean, I'm surprised you can even move your arms. Also, if you are a busty woman, get a jacket that fits you. This is not a good look. You look like the, buttress at the front of a pirate ship, only a really terrible one.
don't eat in your, you don't stay in your cell 24/7, do you?
No. You mean if somebody's in general health?
Let's say you're in SEG. You don't stay in your cell 24/7, do you?
No, there's some time out where a person is allowed outside. I think it may be an hour, maybe more, but I'm not the expert about jail stuff.
Okay, so But you know that there are female guards in prison, right?
And jails, yes.
So you have guards in jail, you have guards in prison, you have access to medical unit, access.
Women are doing it for themselves, standing on their own 2 feet. I forget what the last bit of the lyric is. Look, I'm well versed in the 80s, not quite well versed in completeness.
To the transport people,
Right.
access to.
I'm going to check defense counsel testifying, first of all, and secondly, with the purpose of her being out there.
To enter some records, Your Honor.
I'm assuming you were going to show him a record.
Yes.
Go ahead.
So, how many people in Wise County did Tanner attack?
I don't recall seeing any records of that, no.
How many people in Tarrant County has Tanner attacked?
Again, Tanner is a very specific predator. He is not an indiscriminate predator. In fact, if he were more lower functioning, he might have been an indiscriminate predator. But he is a predator with enough cunning to realize when he would actually be prey, and it is more conducive to him. It is a survival instinct. He plays the weak, wounded puppy dog, but he is Cujo if you are smaller than him. If I were in a room with him, I would not be safe. Now, ma'am, you are safe because you're huge. And I don't mean that as a derogatory comment right now, but Tanner is not going to hurt someone that could fight back.
Same reason. He's been in a solo cell and no acting out.
So you say he's been in a solo cell, but you do know that he has been going to the doctor,
Yes,
that he's been coming to court,
correct.
that in court you had other people with you in court. He didn't try to attack any of you.
No, he didn't attack me.
In fact, this works against the defense. The fact that Tanner has gone through an ostensibly and objectively, increasingly stressful predicament with being on trial and has not had any outbursts, has not had any, tantrums, has not had any explosions, means that Tanner is perfectly capable of controlling himself, which really goes against their narrative that in stress, Tanner's not able to control himself. He just panics and, discombobulates.
He was just angry with me.
Your Honor, I'm going to offer defendant's exhibit number 93, which has already been tendered to, he just never offered it.
This witness laughing at the moranicity of this woman
Defense Exhibit
is
93.
balm to my soul.
And Your Honor, published to the jury.
That's fine.
And
I love how she's like, single female lawyer doing lots of lawing, and he's over here like, God, this woman, will you stop babbling? Like, he's like, bring on your best shot. Pitch me your fastball, your curveball, your whatever other balls there are. And he's like, doink, 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 right out of the stadium. I was going to say concession stand. Y'all know those are the places I would hang out at a sports ball thing. The concession stand.
it requires you to kind of on the table. I can even the records.
So you can file records with the court if there's what we call a business custodian gives an affidavit saying basically these are authentic records of our department or our business or whatever. That's why they're called business records. And they are admissible without a sponsoring witness testifying. So you may accept what is contained in the records in the same manner had somebody been here to testify to them. Okay? Go ahead.
And explain what the affidavit.
Yes.
Okay. What this affidavit is an affidavit of no records from Tarrant County, meaning that they searched the records and they could not find any record of any disciplinary action in Tarrant County.
Again, for the same reason I don't go to Australia and don't, swim in shark-infested waters, because I've done a threat assessment and I don't go there. Tanner is in prison. He's not going to be surrounded by, a cadre, a bevy of victims.
When people are in custody, Dr. Rambula, you said that, I believe you said that they had access to tablets. Was that you that testified to that? Or was
No.
that Mr. Fitzpatrick?
Yeah, that was the
Okay,
TDC
I'm
jail.
sorry. But you've been in the prisons, you've been in the jails before, is that right?
Yes.
So, in talking to inmates, they just don't have to sit in their cells 24/7, do they?
Unless they're in solitary for some reason. Yeah, and again, they get out, I think an hour a day, but otherwise, no, they can roam around.
So in their cells, do they have access to educational materials?
In jails, I haven't seen that as much. In prisons, depends on the unit.
As a part of the educational materials, or I should say as a part of what they can do in jail. And as I said, they have access to the educational materials. They can also do things like Bible study.
Let's be real. First of all, Tanner doesn't know how to read the Bible. He couldn't even read the New Living Translation, which is basically written at a 4th to 5th grade level. I am not joking. So legitimately, they've taken the King James Bible and kind of put it in modern everyday language and written it to about the level of understanding and, of 4th to 5th grade. Now, that's not to, again, demean anyone, but that's to make it a common denominator, easy to understand translation of the Bible, where you don't have to be maybe as sophisticated in your vocabulary to understand the general, message of the Bible. He could not even understand that. I mean, at this point, VeggieTales might be a place to start, but he's not going to go do Bible study. He's not going to do anything. He's going to watch the same episode of Dragon Ball Z thinking he's Super Saiyan for some stupid reason. And hopefully dealing with, his roommate's justice for the rest of his life.
So that my answers are based on what information I've learned from other people who are inmates, because I have no idea how TDCJ administration decides. I've just heard things from individuals. But yes,
Thank you, JKD Buck. I was trying to remember the word for it. Paraphrasic. I read that first and I was like, I know it's not parasitic. Let me go back and read that again.
you're correct. There are some people who can, some cannot.
May I approach, Your Honor?
Yes.
Dr. Rambula, I am going to show you what has been marked as Defendant's Exhibit number 95. And we move to.
All right.
I'll just go.
We are pausing this. We are ready to go for today. Oh, good Lord. This heifer's going to start. The Thunder Cow is starting off talking. I will just warn you. So brace yourself. We are in for Thunder Cowedness.
Understanding that
Oh, don't ask what the school that my little boys go to call the NIV. It's bad.
Includes the pervasive media attention that this case has garnered. There are channels that are on.
Oh, wait. The defense is crying about media attention. You're welcome.
Preclude the imposition of the death penalty and take it out of the hands of the jury. The basis of this is the pervasive media attention that this case has garnered. There are channels that are on a loop 24/7. It's all over social media, and it's not just a little bit, it's everywhere.
Don't cry for him, a poor Tanner. The truth is he's always a schmuck ball. We're making fun of his stupidity. I don't care. Sit down, Sally. Mo, the musical, I've lost my sanity, this woman's to blame, will be off Broadway by the way of Indiana. Coming soon.
We have people outside of the courthouse holding up signs and protesting. We have people online that have created false narratives, that they're flat out lying about what is happening.
Oh my God, are we going to have a Sarah Boone Tanner? They're lying, they're lying, they're lying about me. Well, they use the facts from the court documents, but they're lying, they're lying. The evidence is wrong. It's a trap. It's a conspiracy. Won't someone get Admiral Akbar?
In this courtroom. And I know that this court has given instructions to the jury, and I just don't think it's enough because this media attention has been so widespread. It is impossible for Tanner to get a fair trial in violation of the 5th and 14th Amendments and also in violation of the Texas Constitution. This case isn't just local. It's not just statewide. It's not national. There are international newspapers.
Yes, the world is healing. Peace might be reached in the Middle East all because we hate Tanner. We have united against, even the dyslexics have untied against Tanner. The world is healing. Democrats, Republicans, gays and straights, cats and dogs, they're all coming together over the concentrated and attention-filled hate of the monster that you're representing. You're welcome.
Writing stories about it. And so with all of that media attention, our team has received death threats. Our witnesses have received death threats.
No one should ever do this. I do not appreciate the internet acting stupid. I know none of my chat did that. But as I always say, do not reach out to these people publicly. We shame them, we humiliate them, we verbally, sarcastically eviscerate them, but we do not contact them. We do not harass them in real life because that is stupid and criminal.
Our client has received death threats. And so what we're asking the judge to do, what we're asking you to do, is to preclude the death penalty in this case, because that's the only thing that can remediate the publicity that they have. And the reason that we're asking that is, put yourself in the jury's position. You know that this case is international news. You know that this case is a hot topic. You know that
this was exactly what Rittenhouse jurors had to face, and they were actually followed by the mainstream media. This is apples and oranges. If you wanted to talk about, jury intimidation, we can talk about the, good Lord, why am I having a brain fart? Darren Wilson case. We can talk about the Rittenhouse case. We can talk about any number of these cases that have been incredibly politically charged. We can talk about the current political charge against the Carmelo Anthony case, and that is now going to not be televised. We can talk about a lot of publicity, but no, your client pled guilty, and no, sit down. Bye-bye, Felicia.
Case has raised such passions that it results in death threats against the defense team. You know all of this. Now imagine you as a juror going to church on Sunday, and the person sitting next to me or sitting next to you says, I know you're on jury duty. How'd that go? You were gone for 5 weeks. You must have been on that case. I can't believe you did X, Y, Z. So in taking away their ability to sentence them to life without repercussions from society and from their friends and from the community, that is the only way that Tanner can get a fair trial in this case.
The court daily, even though it's not in the record, the court daily has admonished the jury in the jury room to stay away from media. To the point of last week, I didn't tell the lawyers this, one of the jurors asked me, is the case still getting a lot of attention? So based on that question, I am satisfied that the jury has been following my instructions to stay away from the media. Your request is denied. The jury is present. Are both sides ready for the jury?
Ready.
Defense?
Sure.
All right, let's go. Everyone may be seated. Good morning. Members of the jury, the defendant Tanner Lynn Porter stands charged by indictment with the offense of capital murder, alleged to have been committed in Wise County, Texas on or about the 30th day of November 2022. To this charge, the defendant has pleaded guilty. The defendant has entered this plea, and the court hereby instructs the jury to find the defendant guilty as charged in the indictment. Your verdict must be by a unanimous vote of all members of the jury. In deliberating on the case, you shall consider these instructions as a whole, and you must not refer to or discuss any matters not in evidence before you. Our law provides a defendant may testify on his own behalf if he elects to do so. This, however, is a privilege accorded to the defendant, and in the event he does not testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has not testified, and you are instructed that you cannot and must not refer or allude to this fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against the defendant. When you go to the jury room, the first thing that you should do is select one of your number as your presiding juror, who will help to guide your deliberations and will speak for you here in the courtroom. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media such as a telephone, cell phone, smartphone, iPhone, or computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website such as Facebook, LinkedIn, Instagram, YouTube, or X to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict, if any. If at the conclusion of your deliberations, the presiding juror should sign the verdict form, and I'm requesting whoever the presiding juror is, if he or she will print their name beneath the verdict form and put your juror number next to the signature. If you need to communicate with me during your deliberations, the presiding juror should write the message, ring the jury call button on the wall, and give it to the bailiff. I will either reply in writing or bring you back into the court to answer your message. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and the weight to be given to their testimony, but you're bound to receive the law from the court which is herein given and be governed thereby. And I've signed the instructions as judge. The last page of the instructions contain the verdict form, says we, the jury, find the defendant, Tanner Lynn Horner, guilty of the offense of capital murder as charged in the indictment. The presiding juror should sign his or her name on that line beneath the verdict form. All right? If you retire to your jury room, buzz me when you're ready. All right, we'll be in recess for a few minutes. Yeah,
All right. There is a bit of a grace to realizing you are supposed to start early.
Everyone may be seated.
Presiding juror, it's my understanding that this jury has reached a verdict. Is that correct?
Yes, sir.
You can put forth, please, deputy.
Wait a minute. I thought we got closing statements. Am I confused? Or did we waive closing statements? You guys, I didn't, I, do what now? Okay, I'm going to go back and start him over again. All right. Because we started here. All right. I haven't missed it because that's her bitching about not getting or publicity. Then we take a break. Okay.
Everyone may be seated. Mr. Presiding juror, it's my understanding that this jury has reached a verdict. Is that correct?
Yes, sir.
You can put forth, please, deputy. Verdict says we, the jury, find that defendant Tanner Lynn Horner guilty of the offense of capital murder as charged in the indictment, and it is signed by the presiding juror. Does either side desire to oppose?
No, Your Honor.
No, sir.
All right. Members of the jury, I will now read you the instructions on punishment.
Okay, this was procedural. This was a procedural guilty. Y'all, for a moment there, I was like, oh dear Lord, you are finally having a stroke. This is what feeling like a stroke is having. You have lost time. Legitimately, I was very worried. Now, I am what I like to call a current dramatic hypochondriac. So I will assume that I am having a stroke, not that it was a procedure.
Lawyers will then make their closing arguments. At the conclusion of the closing arguments, you retire to your chair and continue deliberations on punishment. Okay? Members of the jury, the defendant Tanner Lynn Horner has been found guilty by you of the offense of capital murder. Therefore, it now becomes your duty to determine the punishment to be assessed against the defendant. Punishment for the offense of capital murder is by imprisonment in the Texas Department of Criminal Justice for life without parole or by death. In order for punishment to be assessed, two special issues are being submitted to you. Before answering these special issues, if you can, you will consider the following instructions. It will not be proper for you to arrive at your answers by lot, chance, or any other random method. Your answers, if any, must be arrived at by a full, fair, and free exchange of the opinions of each individual juror. Each of you must decide the case for yourself, but only after an impartial consideration of the evidence with your fellow jurors. Do not give up your honest beliefs as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of answering the special issues. Special issue number one, whether there is a probability that the defendant would commit criminal acts of violence that would constitute a continuing threat to society. The prosecution has the burden of proving that the answer to special issue number one should be yes beyond a reasonable doubt. And if it fails to do so, you must answer special issue number one, no. You may not answer special issue number one, yes, unless you agree unanimously. You may not answer special issue number one, no, unless 10 or more jurors agree. The members of the jury need not agree on what particular evidence supports a negative answer to special issue number one. If any juror has a reasonable doubt as to the answer to the above special issue, the juror shall vote no as to that issue. In deliberating on special issue number one, you shall take into consideration all of the facts shown by the evidence admitted before you in the full trial of the case, including evidence of the defendant's background or character or the circumstances of the offense that militates for or mitigates against the imposition of the death penalty and the law as submitted to you in this charge. Only if the jury unanimously answers special issue number one, yes, will the jury next consider special issue number 2. Otherwise, the jury shall not answer special issue number 2. Special issue number 2, whether taking into consideration all of the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, there is a sufficient mitigating circumstance or circumstances to warrant that a sentence of life imprisonment without parole, rather than a death sentence, be imposed. You shall answer special issue number 2 either yes or no. You are instructed that you may not answer special issue number 2 no unless you agree unanimously. You may not answer special issue number 2 yes unless 10 or more jurors agree. The members of the jury need not agree on what particular evidence supports an affirmative finding on special issue number 2. You shall consider mitigating evidence to be evidence that a jury might regard as reducing the defendant's moral blameworthiness. You are instructed that if the jury answers that a circumstance or circumstances warrant that a sentence of life imprisonment without parole rather than a death sentence be imposed, the court will sentence the defendant to imprisonment in the Texas Department of Criminal Justice for life without parole. A defendant sentenced to confinement for life without parole is ineligible for release from the Texas Department of Criminal Justice on parole. The state has introduced evidence of extraneous crimes or bad acts other than the
We will go back and listen to instructions. My brain is too excited and like, let's start. So I believe he said 10 or more, but we can go back and listen because I will be very honest. I was texting Mr. Moe that if he had time during his lunch break to throw in a pizza for me because we've got closing arguments. So I was trying to get my food, game situated. And wasn't quite listening. Oh, has to be unanimously decided. I don't know. I think I'm going to be, it's going to sound a little bit counterintuitive, but I would be okay if he got life in prison. Because coldly and calculatingly, I don't believe he will last very long in general population, and I don't believe he will qualify in time for the segregated population. It also prevents the family from having to go through years and years of onerous, appeals. Now, is that the way everyone thinks? Is that completely coldly logical and slightly sadistic and wishful on my part? Yes. But that's how I would vote because I think it would be much more difficult on the defendant to live in a crowded dormitory. I think he would very much be predated upon. And I would definitely think that he would not last long. And I find that it's about the same equivalent as giving him the death penalty in my logicalness. Now, that might not be something that, everyone agrees with, but that's kind of where I'm leaning right now. But the state may make really good points, and it is Texas. So while there is the appeal and the required appellate, kind of dance, they seem to be, one of the states that's moving forward with capitalizing on capital punishment, so to speak. I think, and here's the other thing, allegedly in Minecraft, if the state does it, it's very clean, it's very clinical, it's very peaceful. I find that having taken in the breadth and depth of the evidence that I'm willing to stomach in this case, I find that I don't want Tanner peacefully slipping off this mortal coil. He did not allow the little girl to do that. I don't know what would happen if they completely disagree. I do believe that if there's any disagreement, it simply becomes life without the possibility of parole. There must be unanimous consent for the death penalty, I believe, but I will double check that. I am not a lawyer. I only play one on YouTube.
one charged in the indictment in this case. This evidence was admitted only for the purpose of assisting you, if it does, in determining the proper punishment of the offense for which you have found the defendant guilty. You cannot consider the testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other acts. Our law provides a defendant may testify on his own behalf if he elects to do so. This, however, is a privilege according to the defendant, and in the event he does not testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has not testified, and you're instructed that you cannot and must not refer or allude to this fact throughout your deliberation, or take it into consideration for any purpose whatsoever as a circumstance against the defendant. You have heard evidence that the defendant made an oral and recorded statement on December 2nd, 2022, and on December 7th, 2022. If you find the defendant did make the statement, you may consider that statement against the defendant only if you resolve a preliminary question in favor of the statement. An oral recorded statement by a defendant made as a result of custodial interrogation may be considered against the defendant only if before the statement, but during the recording, 1, the defendant was warned that he has the right to remain silent and not make any statement at all, and that any statement he makes may be used against him in his trial. Any statement he makes may be used as evidence against him in court. He has the right to have a lawyer present to advise him before and during the question. If he is unable to employ a lawyer, he has the right to have a lawyer appointed to advise him before and during any question. And he has the right to terminate the interview at any time. And 2, the defendant knowingly, intelligently, and voluntarily waive the rights set out in the warning. Therefore, you may consider any statement you believe the defendant made on December 2nd, 2022, or on December 7th, 2022. Only if you first all agree that the state has proved, beyond a reasonable doubt, that before the statement, but during the recording, the defendant was given the warning set out above, and knowingly, intelligently, and voluntarily waived the rights set out in the warnings. If you do not find that the state has proved these things beyond a reasonable doubt, you must disregard and not consider for any purpose any statement the defendant may have made. If you do find the state has proved these things beyond a reasonable doubt, you may consider the evidence that the defendant made the statement and give that evidence whatever weight you believe appropriate. In deliberating on this case, you shall consider these instructions as a whole, and you must not refer to or discuss any matters not in evidence before you. You must not consider nor mention any personal knowledge or information you may have about any facts or persons connected with this case which is not shown by the evidence. You shall not consult law books or anything not in evidence. You are charged that it is only from the witness stand that the jury is permitted to receive evidence regarding the case or any witness therein. And no juror is permitted to communicate to any other juror anything he or she may have heard regarding the case or any witness therein from any other source other than the witness stand. When you have arrived at your answers to each of the special issues of it, you may use the attached forms provided at the end of these instructions. Any further communication with the court must be in writing, signed by your presiding juror through the bailiff. Do not attempt to talk to the bailiff, the attorneys, or the court regarding any questions you may have concerning the trial of the case. You are the exclusive judge of the facts proved, of the credibility of the witnesses, and the weight to be given to the testimony, that you're bound to receive the law from the court which is here and given and be governed thereby. And I've signed the instructions. The last 2 pages of the instructions contain the answers to the special issues. Special issue number 1, whether there is a probability that the defendant would commit criminal acts of violence that would constitute a continuing threat to society. There are 2 possible answers. We, the jury, find the defendant unanimously beyond a reasonable doubt that the answer to special issue number 1 is yes. Or we, the jury, have at least 10 jurors with a reasonable doubt as to the matter inquired about this special issue and find that the answer to this special issue is no. If either one of those is the verdict of the jury, the presiding juror should sign the appropriate verdict form. Only if you answer yes to question number 1 unanimously will you answer special issue number 2. Otherwise, you will not answer special issue number 2. Special issue number 2, whether taking into consideration all the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant. There is a sufficient mitigating circumstance or circumstances to warrant that the sentence of life imprisonment without parole rather than the death sentence be imposed. Again, there are two possible answers. We, the jury, find the defendant that the answer, unanimously find the answer to special issue number 2 is no, or we, the jury, have at least 10 jurors that agree the answer to special issue number 2 is yes, and find that the answer to this special issue is yes. The presiding juror should sign his name on the space beneath the appropriate verdict. Mr. Staple.
Thank you, Your Honor. It's been a heck of a month. I want to thank you up front for being so attentive and giving us your time away from home, away from your families, away from work. We appreciate that. The way it works today is I've got a few things to say. The defense will have a few things to say, and then I will finish, and you will get the charge of the court that the judge just read you. I'm not going to go through all the evidence in the case. I don't have enough time. The judge gives me an hour, and then I get the hook, so to speak. But I do think there are some things that are important, and this is the number one thing that I think is most important right here. This is what's most important. This is why we're here.
Amen. Amen. It has been torturous, grating, and beyond that feeling when you get that like icky, you need Purell over you, that sort of viscerally gross feeling, to have to listen to poor Tanner as if he is a victim of any sort, compared to this beautiful little angel. And I am so glad. I am so glad that again we get to have the state be respectful, dignified, and restrained. He's not going to pull out all the terrible things. He's going to be powerful and he's going to be restrained, and it's going to be so much more powerful because it's not gory, because it's respectful.
This picture sat in my office for months, and I looked at it every day. And it's a reminder on those days, why do I get up again? Why do I keep doing this? And this picture was taken, she didn't know she only had 4 days left to live. So that picture was taken. When that picture was taken, I didn't know that 6 days after that, I'd be talking to my sheriff, and you heard from him, a former Texas Ranger, a fairly grizzled veteran of law enforcement, that I'd be sitting there with him and not a dry eye between us. I knew then that I would be here in front of you. But why are we here? We're here for her. We're here for her memory, her voice, a little bow on her head, smile on her face, love in her heart. That's why we're here. She can't seek justice. We're here for her. When you all got qualified and we went through the whole process, talked about a lot of things. And one of the things that I think we talked about is the death penalty, and a lot of people are reluctant on that, and we should be. And it should be used in only the most extreme cases. Now, those cases, intentional, cold-blooded, planning, premeditation, victims that can't help themselves, children. Cases where the victim is sexually assaulted prior to their death. Cases where there's no mercy shown to the victim. Cases like this. This is what, and the reason why that Texas keeps the death penalty here. This is why. This is the type of case And I'm going to tell you, Tanner Horner is proof why parents hug their children a little tighter. He's proof of why children are nervous to go play outside. He's proof of why there is evil in society and we can never turn our back. Now, 2015, May 23rd, Athena, she was born. 18 days from today, she turned 11. 18 days. If you remember on opening, we talked a lot about past tense. And I'm not even trying with the glasses anymore because my eyes are smoked after this trial. We talked a lot about would. We talked about past tense. And I think it's important. We've heard a lot about people's past, but I think it's important to talk about what would have been. You know, when we talk about Athena, I feel like we want to talk about when she would have graduated. She would have been a Paradise Panther, class of 2033. She would have celebrated her birthday party in 18 days. And I can promise you there would have been an overload of pink. That's all would. Okay. The other questions we look at is the future. We look at, you know, when you look at it, you ask yourself, you know, who would she marry? Who would be her first boyfriend? Real boyfriend. You know, some things that I thought about is what kind of shoes would she wear under her wedding dress?
Oh my goodness. The state, again, this was what I had hoped that they would do in closing. We've talked so much about Tanner's childhood and his horrible adulthood and everything, but the defense did not think about all the things that Athena's family lost. They lost the thought of what kind of man would she meet or person would she meet? Who would they fall in love with? These are all things that I'm sure torture her parents. And the jury needs to feel a little bit of that because that's the reality. At the end of all this legal maneuvering, at the end of the strategy and the statutes, that's what they're here to adjudicate. What punishment is deserved after you do that? And thank you, State, for being so incredibly respectful. Sorry, I'm trying not to interrupt, but they do kind of get mad if I don't interrupt, so.
Important. Who would she marry, right? What kind of job would she have? That's what's important here. Her future. And the fact that Tanner Horner cut that short. Brutally cut that short. So that's why we're here today. Tried to do all this by memory. It just doesn't happen. We've been here 5 weeks now. It just doesn't happen. So the big thing here is this case is going to require a tough choice. We all know this. But the right thing is often the toughest choice. Now, we're taught as baby lawyers, we're supposed to get up here and bring all the fire and brimstone. And I can assure you, I can generate some fire and brimstone. But this isn't the case for it. I can't do any more or say anything more than what you've already seen on that screen. There's nothing I can do. There's no amount of fire and brimstone. There's no amount of jumping up and down and being like that could ever come close to what you've already seen. And I'm not even going to try. The evidence in this case, I'm not going to go through it because it is massive. But the big point of all of this evidence is this. If you start at the beginning, you know the facts. You heard the facts. When I came up here in opening, I told you I was going to put you as close as you could be to actually being there. And I did not lie. In this case, the evidence, you know, we talked about the worst of the worst and the cases that that like this, cases that have planning or premeditation. Don't discount the fact that somebody decided to cover up the camera an hour before, 2 days in a row on exactly the same road with 2 different locations with 2 little girls that were there. You saw the videos. My suspicion is those husband girls would have been first if the parents hadn't come out. They were first. Only when that didn't happen, Athena was second. So the evidence speaks for itself. You know, when you talk about planning, it's not all just pre-planning. It's the understanding of what you're going to do after. You know, for somebody that is having some form of catastrophe and inability to think or solve problems, out of all the random roads you could have chosen to go and sexually assault Athena, you drive right to it. You know the road, you know what's going on, you know the bumps, you know what's there. You don't pick some random road. You go to where you know it's secluded. That's planning. That's not somebody having a catastrophe and doesn't know where they are. Okay. So we know what he wants. We know because you heard it. One.
Judge, can we purge?
I am not sure what's going on.
Can all the members of the jury see?
Okay, I do want to stop here again to I don't believe we are going to see anything of a graphic nature, but we are it looks like we are showing video. Obviously, the court and court TV have been really good at making sure we, the streaming public, don't see what we're not allowed to see. But some of this video footage is incredibly, incredibly um, hard to watch, even even without the graphic nature of it. I do believe that they are alleging that he was not able to perform during that. I don't care. There was DNA found in places that it should never be found. I find that I don't care whether he can perform or not, or did perform or not.
The board. Board is a little small. We know what he wants. And we know what's coming. Athena didn't know what was coming. He knows what's coming. That's not the eyes, that's not the look of someone who doesn't have a plan, doesn't have motivation, that hasn't thought this out, that hasn't fantasized about this. That's the look of a predator right there. Now, about the evidence, you know what happened. I'm not going to go over that anymore. There's a couple of things here that I think are important. I talked to you about DNA, and I think DNA is important. The only acceptable answer in this case is that Tanner Horner was excluded. That's the only acceptable answer. And that's not the answer we have, period. It's not that, well, we found some DNA, it was his, but, you know, maybe it's not enough. It's like when Dr. Ryan got up there and said, well, he's not a pedophile. It only happened one time. I beg to differ with that. Now,
And And again, it's just these I don't know if this defense team ever thought they were gonna gain any sympathy. These are opinions that are so contrary to everyday people. If you did a survey, if you did a study of how many people would be okay if you just did it once, I think that no one would be okay if it was just one time. I mean, I think it would be a very, very small people. Again, these are just views that are so contrary that there's no way that you could persuade anyone because you are unable to see the validity of the other side. You are so blinded by your own ideology and your own Ivy Tower thinking that you can't realize that your opinions are so completely alien to the everyday human that we look at you like you're aliens. We're not stupid rubes who can't comprehend where your thoughts are coming from and the ideology they spring from. No, we can't comprehend a smart person being able to bend themselves in such mental pretzels to make some of the statements that you guys made and charge money for them after watching these videos. That's what we don't get. We're not dumb rubes. We're confused at the dumbness you're showing.
When we talk about the murder and what happened, you guys heard it. And I don't want anybody to ever forget what kind of warrior that little girl was. I don't know if anybody could have withstood what she withstood over and over again. I don't know anybody that could have withstood that. He can choke her. He can beat her. He can do it over and over again. But what do we know? We know the end result was right here. This is what it took. That's what it took to beat the life out of her.
And if the defense doesn't think that there are not inmates all over Texas hoping he comes to their intake center, if you don't think that there aren't inmates in jail who are watching court TV along with the rest of us, Jumpsuit Pablo and, JD, I forgot his name. I'm terrible with name. I'm dead awful. But those are 2 gentlemen who have had former pasts with prison and changed their lives, and they have said that when cases like this come along, prison inmates are very, very interested. They want to know the evidence because they don't like this. They want to know all the evidence because they wanna know who's coming into their city. That's another thing. So
And I think that is key to this entire case. If the facts were not bad enough, if the sexual assault wasn't bad enough, the level of violence that one person can inflict on a child, including stomping them with a pair of shoes, and I wonder where that tread-like print came from anymore, because we know. Now, like I said, the defense is going to get up here after me. They're going to have some things to say as well. That's how it works. Okay. But what I anticipate is going to be a continuation of what you've already heard. His brain's broken somehow. He's got all these conditions. He's got all these ailments, all these things. He may have some or part of those. Apparently, according to Dr. Young, he even got low T. We even got the lead paint guy. Now, I don't know about the lead paint guy. I don't know if it works or not. I don't know if his little homemade zapper works or not. I honestly don't know. But what I do know is this. If you're going to come in here and try to convince us that somebody has all this lead in their system, it's causing all the problems, why do you test anybody else? I mean, if you want us to believe you and all this stuff's going on, why don't you test the other people in the house? I don't think you want to know the answer. That's why you don't do it. So when we get up here, it's going to be a lot of talk about second chance. It's going to be a lot of talk about, maybe mercy. There's going to be a lot of talk about, his deficits and disabilities and things of that nature. But let's remember this. Everything they're telling you is an excuse. You know how I know it's an excuse? Because it took 6 or 7 experts and $500,000 to come up here and tell you it's not an excuse. That's how you know. If you've got to work that whole.
Oh, damn. Oh, damn. Someone call an ambulance. Someone call an ambulance. Someone call CNN. There's been an assassination. Someone call. Does anyone know? In the arms of the angel. Does anyone know where Sarah McLachlan is? Can someone contact the defense? Because they are DOA. Oh, my damn. Well, someone's going to get. Does anyone have some Bactine? A little Solocaine? Anyone got a lidocaine patch? Oh, that hurt Sally, Timu Bonnie right in the heart if she had one. But Uno reverse, the prosecutor knew that she doesn't have one. He hit her in the ego. And Mortal Kombat fatality.
Hard to try to prove that some kind of excuse. We know what the answer is. They're trying to get you to excuse his conduct. They're trying to get you to be less angry or less blameworthy on somebody for their conduct. I submit to you the truth and the facts and circumstances are what's most important. What he did is most important. Now, in looking at all of this, if you want mercy and you want somebody to consider giving you life when you gave no life here, when you gave no mercy here, what does it start with? I like to think it starts with the truth. I like to think it starts with not lying. I like to think it start with, if you have experts and you're being interviewed, not continuing to fabricate stories, not continuing to lie to you, not continue to try to cover, not continue to try to shade this or change the narrative. I think that the difference between wanting mercy and earning it are two separate things. So now, what you've heard for the past 2 weeks is that person driving that vehicle, you can see it right here, this person right here driving this vehicle. You've heard for the last 2 weeks about every form of ailment one could possibly have. And you heard about the last 2 weeks how that person can't cope, has stress, has the inability to do basic.
Aaron, we are at closing statements. I will say the state is being very restrained, but because he's being so restrained and so eloquent, it is hitting a lot of us really hard. There's tissues and sniffles. I will be doing a puppy kitten break after he, sits down before the defense is, going to give their closing arguments. But did want to let you know that he is putting on one hell of a close. And it is very effective. So have your Kleenex or hillbilly Kleenex toilet paper on standby.
Basically anything on the earth whatsoever that essentially is incapable of doing anything. If you have any doubt about that, Watch the 8 minutes of this video right here, from when he pulls in to Athena's driveway until he covers up the camera. If you have any doubt about somebody's ability to do and participate and be out in the world, watch that video. Because it's real clear. That's an individual who knows what they're doing. That's an individual who's hunting. That's an individual who's looking around and understanding what's around them. That is an individual who is absolutely lethal. That's an individual who targeted somebody, found somebody, tricked somebody, got him into the vehicle. You all saw when he took his hand and he put it over her mouth. He knows what's coming. You all saw right here. You all saw right here. Bungee cords, trying to tie somebody up. You all saw that. This is not an individual that's on some form of stress-fueled catastrophe. And the cocaine nonsense, come on. Just another lie. Just another lie. But guess what? When you know that you've been caught covering up the camera, and you know you're being caught, what do? You come up with another lie that fits your narrative. That's what you do. And that's what's happened in this case. It's lie upon lie upon lie. This person driving this vehicle, cool, calm, and obviously, you know, lethal. So, are you going to believe what you hear up here, that this person is basically can't even get up in the morning? Or are you going to believe your eyes and what you see and hear? The only sentence in this case that gives justice to her is answering those two questions. Yes and no. Thank you, Judge. Mr. Goble.
Oh, all right. We've got baby Huey. At least we don't have to listen to Tim Bonnie Raitt's annoying voice. There is something about a HR, moral superiority voice that just drives me nuts. But we are having a puppy kitten break. I find baby Huey easy to ignore, and his voice, because he is afraid of the mic, we don't ever quite hear him. So I find him markedly, like 2 standard deviations, less annoying and offensive than the female.
When the world feels like a dumpster dive and humans forget how to thrive, take a break, just you and me, with a puppy and kitten, wild and free. Paws and purrs, let's drift away to a land where tails wag and play. No more noise, just gentle muse in our furry four-legged cruise.
Sorry, I can't type and do 2 things at once. But we are going to be listening to the defense. Again, I do hope that some of the rulings, like I know that the defense today did ask for, before the verdict was handed out, like the perfunctory verdict of guilty. She did ask the judge for a judicial ruling that only life without the possibility of parole could be considered as a punishment in this case, due to overwhelming media involvement, media coverage in this case, along with, and again, for legal and, YouTube-y reasons, but not only that, moral reasons. Do not contact these people. Now, she has claimed that witnesses that have spoken for the defense and the lawyers themselves, along with the defendant, have received unaliving threats. So she did ask for that. Now, the judge overruled that. Yes, Steve Gosney, Aaron. I am surprised. The defense has been really good at this most of the trial, and maybe they are doing a calculated sort of strategy. Um, but during the openings, they did stop, I believe, and ask that Athena's picture be put down and the video be put down. I am very surprised that they haven't made any, remarks regarding that because they have been pretty pretty good at noticing and really objecting to those points. So in that sense, they have been incredibly zealous and attentive lawyers for their client. I have also reached out to Tony DeWitt regarding the witness yesterday, um, who the defense. I know that the defense does not have any obligation to turn over inculpatory evidence to the state, but it does seem incredibly slimy that they didn't make their experts aware of their of potential familial allegations of SA when they were compiling their reports and getting collateral witnesses. It seems like the defense purposely kept this witness from their experts. And I did wonder if there were any sort of ethical, maybe ramifications for that, considering the way it was presented and the fact that he spoke to multiple defense members and said he wanted to get in touch with the state. Again, I know they're not obligated, but it did seem kind of like a quagmiry thing that could have been possibly seen as a shade too far in bending the rules.
I do want to start by echoing what Mr. Stanton said. This jury, I think about every one of you, said something to the effect of, you didn't really want to be here, but if it was your civic duty, you would do it. And I appreciate you all showing up every day.
To be fair, I am trying to. There are certain defendants, I always say this in trial. As a defendant, you are judged a lot on your optics, and you're kind of damned if you do, damned if you don't. If Tanner purposely cried all the time, we would assume that he's faking it. He's remained stoic, and we're using it against him in a negative connotation to say, well, he can control himself now. So there is he could have done that much more respectfully, in my opinion, but I also know that I'm hypersensitive in this case. So I'm trying to be the devil's advocate and try to be objective. So while it probably rankles me, I do know that I'm more hypersensitive on this case.
And to punctual, it's hard to pay attention to everything. I know we put on a lot, and not every jury does that, frankly. And you all have been really impressive, and I appreciate it. Now, you already did the first part, rendering the verdict that he's guilty of capital murder, according to his plea. That means he will spend the rest of his life in prison. We know that. The prosecutor gave you the list of different charges. Whether or not that gets a death penalty is not about comparing different capital murders. It's not about whether comparing what happened to Athena to a mass murder, or to the murder of a police officer or a judge or anything like that, and which is worse. We've already told you that Texas law is always satisfied with life without parole for a capital murder. This case, any case, the worst case you can imagine.
I will say I do appreciate this particular lawyer. him doing both the opening and the closing, he's very measured. He doesn't kind of bring the fire and the brimstone. I like that he's approaching this kind of very legalistically, because I do think that this is kind of where I imagined we were going with the defense. It did kind of devolve into, let's bring on every single person to show how Tanner was the victim. Um, and I think that it could have been foreseen that that was the way that would have been interpreted and brought together better. But I do appreciate his cadence and his tone. I'm a very finicky audio person, so I can be put off just by the tonal quality of someone's voice, not by their argument. I will listen to their argument, but their voice will annoy the ever living snot out of me, okay? I do have principles, but I will complain about it.
You talked about what you would do in the punishment phase is different than the fact-finding phase. It's different than that guilt innocence phase. I told you that it's going to be your individual moral judgment. Now I want to point out to you in your punishment instructions, the judge included some language in here, just what we told you before. Each of you must decide the case for yourself, but only after an impartial consideration of the evidence with your fellow jurors. Remember we talked about what deliberating means. We're attorneys. If we meant for you to argue, to fight, to berate each other, we know what those words are. The judge put it an impartial consideration of the evidence with your fellow jurors. But he also added, do not give up your honest beliefs as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of answering the special issues. The special issues are how we decide whether or not Tanner gets a death sentence. I am completely satisfied that all of you took your oath and meant it. Now what that means, and I'm only going to talk about special one, is that you have to apply this, whether there's a probability that the defendant would commit criminal act of violence that would constitute a continuing threat to society. And Susan or I explained to each one of you when we talked individually that this is where that individual moral judgment comes in, that you're going to define what these terms mean, what a probability is, what a criminal act of violence is, what continuing is. And though the prosecutor and a lot of you gave you some suggestions that could be ongoing for continuing acts of violence, could be something, assault, things like that. But that's ultimately going to be up to you. We did talk about society being prison, a more secure society than any of us live in day to day. I'll get back to that in a minute. But remember, this proof has to be beyond a reasonable doubt. I told you before, I gave you the sample. All that language is still here. Prosecution has the burden of proving that the answer to special issue number 1 is yes, beyond a reasonable doubt. Frankly, they spent their 2 weeks proving the case that he pled guilty to, talking about lying and waste of resources. They didn't put on any evidence that Tanner Horner is going to be a continuing threat to society in prison. Nothing. Your instructions are you may not answer the special issue number 1 yes unless you agree unanimously. You may not answer it no unless 10 or more jurors. We went over that, 10, 11, or 12 to answer the no. But I just read to you, you're not to give up your individual moral judgment. That's what you need to bring back to the courtroom. So if you don't meet that 10, you don't meet that 12, that's fine. The judge knows what to do. We've already told you, leave that blank, have the foreperson sign it, and the judge will take care of it. There's no mistrial. There's no hung juries. This is capital punishment and it's different. I do want to talk a little bit, even though Tanner did plead guilty, I do want to talk a little bit about the prosecution's case. He told you his theme was lying. Brought it up again. There's nothing about lying on here. Frankly, go back to creation.
There's nothing about lying. I mean, yes, he's not charged with obstruction of justice or impeding an investigation, but he was absolutely and objectively do what now? Okay, I'm gonna, I have an open mind, not empty. I'm willing to hear him out.
And lying was humans' first reaction to getting caught doing something bad. Deputy Amy handled every piece of physical evidence in this case, handled every photograph. She did something wrong, and she lied, and she lied again, and she lied again, and made it all worse. This isn't about lying. Ranger Espinoza told you he lies as an interrogation technique. He lied in this case to get the information he wanted.
Again, this is something that the Supreme Court has decided is okay. And if you watch true crime and don't felony, you're kind of okay. In fact, even if you do felony, if you watch any criminal defense attorney on YouTube, you will learn to shut the heck up, get a defense attorney, and then they can't lie to you about the information they have against you. Holy Fazoli buzzballs.
This case isn't about lying. You don't get the death sentence for lying. There's a thing with our experts. Every one of them, they asked them about insanity. Tanner pled guilty. We didn't raise the not guilty by reason of insanity defense. That was a waste of time. They argued that Tanner wasted resources. But they played you that December 7th video. Now, had I been his attorney on that date, I would have wanted to be there. I don't think it's right that you interrogate somebody after they have an attorney appointed for them, or when they're asking for an attorney. But they did it anyway, and what he did was offer to plead guilty, to plead no contest, to accept the minimum of life without parole. And he wanted out for Christmas.
How flippin' flapjack magnanimous about him. Good Lord, you are testing every fiber of non-cussitude I have. You are trying, look, there are ways that you can constitutionally defend this festering thunder cow, okay? This festering anal fistula on humanity, all right? Allegedly in Minecraft, do not look that up. It will haunt your nightmares. You have been warned. But it is factually true. He pled no contest because the evidence was stacked against him. We basically have an audio snuff film. How dare you, sir? This is not an argument that would win any favors. I don't understand. Again, this is, if you really wanted to defend Tanner, this is not the argument you would use. This is, I don't even know what this is, but this is not persuasive. This is inherently offensive and disrespectful, and at least outside to me objectively. And I doubt that I would be, I would be a minority among the jury. Again, after that audio was played, there are certain arguments that are going to be seen as catastrophically and exponentially more offensive to people after that particular piece of evidence drops. And this one is not great.
And they mocked it. He wanted out for Christmas with his son, and they made fun of him. Like that wasn't reasonable. He could have been out that day if he'd had cash. He had a bond. Him going home for Christmas was not unreasonable. Beginning a negotiation with an offer and an ask is what happens every time. Most cases in America don't go to trial. They're pled out. Now the answer can be, no, we want you to plead guilty. No, we're not going to agree to a lower bond. That's what negotiation is. Frankly, if you go to buy a house tomorrow, you're going to make an offer of what you're willing to pay for it, and you're going to ask for the refrigerator, or for closing costs, or for something else. And the other party may say no, and you may still end up buying the house. This case could have been over in December of 2022. No one took it seriously. I don't even know if it went to the prosecutors. Definitely didn't get to a judge. That wasn't ridiculous.
So now no one cared about Athena, but you guys. I take back everything I said about him, because during the opening, he was mostly factual. He stuck with the legalism, and you can't judge, this brain that's abnormal. But he seems to have taken on a smarmy, smugly attitude. And when your client is charged with this, that's not the way you want to go. I know Tony DeWitt has talked about this, and I believe so has Runkle of the Bailey. But when you have an incredibly hard to sympathize, hard to humanize client, you have to be the avatar of human goodness. You kind of have to be the straight person, the honest person, the good thing that the jury can kind of get the evidence through. They need to be able to trust you when you say, my client, yes, I know he seems like a monster, but I know him. I got to know him, and he is not only defined by this moment. And you don't do that when the jury learns that there was a witness. I mean, they don't know that the witness went through the defense, but the way the defense has shaded this is not the way a reasonable person would have interpreted most of this evidence. All of their experts denying any culpability, any sort of side effects of his taking of illicit drugs, in self-reports that indicated that it was frequent and it was increasing before the incident. To say that was self-medicating rather than that could have increased, an already unstable mind, it could have increased instability. So they could have gone along those lines, and I think that would have been a zealous and perfectly acceptable use of all the resources they had available to them. What they came at was Schrodinger's autism, where he was as dysfunctional enough to basically not be able to tell colors from letters, but somehow magically able to, at other times, drive a car.
Ridiculous. No, yeah, you've seen his videos. Everything Tanner does is off.
Fair point, Aaron.
So maybe they didn't take him seriously because when he made his offer, he sounded weird. Oh, of course we're not going to let you out for Christmas. He could have been out that day. $1.5 million bond. It's America. If he had cash, he would have been walking.
Okay, now, again, I am a twice college dropout, but I don't think there is a timeline between here and infinity where Texas allows a person basically caught dead to rights to have bond at any point in time. I mean, I could be very wrong, but there is not a conceivable way that I would think any judge would allow this to happen, even in like Guam.
So to mock him for it is frankly, it's ridiculous. I deal with a lot of clients that don't know how to negotiate. That's why the attorney should have been there.
They weren't making fun of him. They were completely flabbergasted by the fact that he thought that this would ever happen, ever. Oh, thank you, Aaron. He did have a bond. It was $1.5 million.
The other thing that's kind of frustrated me in this case is and I hate to belabor it, the kind of the
Oh no, please tell me what frustrated you in front of the family that lost their daughter. Aaron, honest to God, it is things like this that have pissed me off. I can deal with smarmy attitudes. I can deal with elitism. I cannot deal with that attitude. I really, really can't.
representation of some of the evidence. Going back to the medical examiners.
I believe horrifically he is going to be getting into the allegations of SA against Tanner or against Athena. Now, I know that the defense has hotly contested what the finding of DNA in certain parts and on certain parts of her body has meant. Um, but I do want to give you guys a heads up that we are probably getting into that territory. Um, we will take a puppy kitten break as soon as he gets off of that subject, or if I feel, but I do want to give you guys a heads up that that seems to be where we're going.
And you have all these reports. So if you're in
Oh, now there's 5 of me. That was a weird one, but now we know it's all YouTube's fault, and I mean, at this timeline, makes perfect sense. Now, oh dear Lord, Penny Problem Glasses is going to talk. Oh Lord, how long is she gonna talk? Oh, you only get an hour, ma'am. Alright, let's see if we get back to where baby
the
Q
drug issues, trying
crying about what really ticks him off about this trial.
to do vocational training, do education, all those, or you committed violence while you're in prison. Every time it got brought up, I tried to object that these were somehow proof of sexual assault. They're just not. Medical examiner's report and the DNA reports. The actual issue, whether or not he's going to be a continuing threat to society. We started our case with Professor Edens, who has actually done research on what matters, what can be predicted, what isn't predicted. Actually looked at Texas inmates who had people testify that they were going to be future danger. Some of those people were on death row, some had life without parole, some got exonerated. Proven they weren't guilty and they went home. But all of them had people saying that they
Yeah, and apples and oranges are different fruits, but you can still make a tasty salad with them. Seriously. I will say, Aaron, I don't think that the state did as good of a job on the continuing threat argument, except for pointing out that other people, if he is given contact visitation, um, won't know, and he could possibly have access to children through that. Um, I don't think that the state made a completely effective case. I wish that their expert had been a little bit more forceful because I think there was an argument there, but I don't think he was as forceful as he could have been.
were going to be a future danger without any research to back it. Now, Professor Edens did say there are things that do matter. If you go to prison the first time between 18 and 21, if you have lower education, don't have at least a high school diploma or a GED. If you're a member of a gang on the outside or when you get in, there's a higher likelihood there's going to be violence. And if you've been to prison before or you've committed violence while you're in prison. This would seem like common sense, but he also went through the hard work of researching it and teaching people how to look at this. For Tanner, none of those apply. Tanner was 31 when he went to prison. Tanner is not the person you see on the news who's been arrested 31 times and released despite it being violent crimes. This is Tanner's first time. He has his high school diploma. not a member of a gang, obviously.
No, but that's like saying Chupacabra isn't a monster, but Bigfoot is. They are in fact both cryptids. So you could the more intelligent way to put this is that Tanner is not the kind of monster that we typically see causing issues in the prison. Now, you wouldn't say monster, but you would say inmate. But you would have to concede that they both could be classified as monsters or cryptids.
2 jails, plenty of people, female, male, volunteers, religious meetings. You've heard, obviously, every expert we brought up here. He went to visit them, transported for his brain scans, transported between the jails, transported to court. No write-ups with either group of people. No write-ups in either jail. Then yesterday we got to hear someone who's actually putting these kind of ideas into practice. Director Fitzpatrick is in charge of classification. He told you his top priority is public safety. Safety of staff, safety of visitors, safety of inmates. 142,000 inmates plus in TDCJ right now.
Now, he also misstated a fact, according to Mr. Fitzpatrick. It's not if you were in, you would be more likely to end up in segregation, not if you had been in a gang outside of prison. No, he specifically said these are intra-prison gangs. These are gangs that operate within or mainly within the nexus of the prison. So you misstated a fact. It's not if you were in a gang before or after you joined jail. It's if you are a high-ranking member in one of those intra-jail or prison gangs. I do pay attention, and I sort of have a semi-eidetic memory for audio information. It's kind of annoying. I only do it now, like, on things. It's intermittent now.
30,000 employees. 29,000 approved visitors. If all of them were subject to violence, that wouldn't be true. We'd have 29,000 volunteers. Director Fitzpatrick told you he uses evidence-based practices to classify people to determine where to house them based on their needs, but number one, based on safety. Takes a holistic approach. Looking at medical, looking at mental health, looking at history, criminology, trying to rehabilitate if there's drug issues, trying to do vocational training, do education, all those things that would hold you back, it might bring you back to prison. Let 50,000 out, 56,000 in. He's thinking about that all the time. Individual treatment plans for rehabilitation. Complete medical and mental health workups before they do the classifications to know what they need, where they're going to need to be housed. 34 facilities that all have different ways to house somebody. There's a classification profile for each inmate that's constantly updated. Incentive programs. They try to make like parole is the only incentive. It's not. Where you're housed, whether you can work, freedom to move about. Those are all incentives. I remember I told you, yes, this is a society, but it's not our society. This society has 24/7 security. It has trained staff, appropriate screening for the visitors. I can make it sound like they're walking around here, but no, mass movement is when a group of people have a place to be, and they have to be moving to where they're supposed to be. Otherwise, individually, you have to have that path and be going where you're supposed to be going. It's not a free-for-all. And ultimately, their expert said they have a reasonable and effective way to house someone who's been sentenced to life without parole while ensuring the safety of the public, the staff, those visitors, and the inmates. Did have one point of contention. Tanner Springer-Marius testified. And I will tell you, I've had a lot of cases where someone was supposed to testify that was in the jail with my client. It's the first time it's ever happened. I'm glad I did. I found him interesting. But he disagreed with Director Fitzpatrick that there are predators and prey in prison. He said there are wolves and sheep. And to his face, he kind of had to describe his friend Tanner as an itty bitty little baby lamb. He's trying to prepare him for what he's moving into. But you've heard what a struggle that is. And finally, you don't have to believe any of these. You've seen it with your own eyes. The state played all these videos for you. You've seen what Tanner's like around authority figures, around security. You can see how threatening they thought he was. The arrest video, completely compliant, no resistance, does exactly what they tell him. He asked about maybe moving his cuffs because they were uncomfortable. They just took his cuffs off. Don't worry.
Again, Tanner's victimology indicates that yes, he would not be aggressive with anyone that he thinks he's going to be getting something from that he can manipulate, but also with anyone who has authority over him, because that's not the way his predatory nature, works. He goes after people that are smaller and weaker than him, whether it be a female, just being smaller, or a child. It is a pattern that we've seen through multiple witnesses. And again, to kind of be this smugly and smarmy when we have seen evidence to the contrary, I can't imagine this is going to work.
About him. Standing there drawing on the board, they're standing right next to him. I don't even do that always with all of my clients. Because you never know. I have some that are dangerous. Tanner's not. They stood right beside him. Nobody was worried. They drove him around looking for Athena. No incidents. They put him in the front seat. Stood outside chatting with him about Waffle House, smoking a cigarette. Nobody's worried. And while
I have to show you guys this because I believe JKD Buck might be right, but I was noticing the facial expressions. Now she's doing good. I do have a resting sarcasm face, so I totally get it. Like my face does resting WTF, and I might legitimately be actually like trying to learn from you, but my face looks like I'm being a sarcastic ass. So, and I've had to tell people like, okay, I'm going to ask a question and it's going to sound like I'm being a sarcastic asshole, but I am genuinely stupid about this particular subject. And this is a legitimate question. So I will give her the benefit of the doubt. Maybe she does have resting sarcasm face like I do.
tried to give you evidence, the state played those videos for you. Ultimately, the burden's on them. They have to prove beyond a reasonable doubt that Tanner Horner is going to be a continuing threat to society in a prison setting with his classification, G3, with their constant workups, with the many housing options they have, that he's going to be a continuing threat to society, and he just isn't. So that's where we come back to that oath that you all took to follow the law. And this is the law. The law isn't that you get the death sentence because that capital murder was worse than the other capital murder. They're all terrible. This one is terrible. But he will spend the rest of his life in prison for it.
Sanders.
Now, I have been incredibly mean to her. I will say kindly, because I'm trying to be a better person sometimes, that green is an incredibly lovely color on her. And I think that it's very nice. It matches her features, and all things set aside, she is a handsome woman, and, usually she dresses pretty appropriately. Now she is very busty, and I joke about that because I'm busty. I don't think that a dummy cup is a good idea for opening or closing statements, but that's just a me thing.
Good morning. I'm here to talk to you about special issue number 2. I promise you, I'm not going to sit up here and rehash the experts' testimony. You have the reports, you have their notes, you heard what they said from the witness stand. I'm also not going to stand up here and rehash all the evidence. You heard the evidence. And if you have
I do like both of these stances. Again, um, th I like where she's going with this. I have a feeling I'm not gonna like where she ends it.
questions about what the evidence showed, you have the absolute right to come, to knock on that door and ask the judge, hey, we have a question about that evidence. But when it comes to special issue number 2, we're talking about the mitigation aspect of it. And we only get to special issue number 2 if each and every one of you has decided that the state has proved their case beyond a reasonable doubt that Tanner Horner is a continuing threat to society. Only if all 12 of you agree will we even get to this part. But in order to understand this, in order to understand the importance of mitigation, especially in this case, you have to understand child development. Because understanding how a child develops is key to understanding the man Tanner is today, but also
Okay, defense, no, crud, wrong button. I do this for a living. Where should we prosecute? No, but legitimately, where should we hold accountable? Where in the genealogy of both families, maternally and paternally, can we find the root cause of the trauma and adjudicate it guilty? Because I do think that there are serious discussions to be had about early childhood intervention, modalities, and, parental involvement, and whether there should be parental accountability since we seem to be going down that road anyway. Um, what I don't understand for the defense is, where does it end? At what point can we hold anything beyond society, accountable, I guess? At what point do we not take away agency from Tanner because his brain works neuroatypically? Where do we draw the line between you are predestined by these maladies to be unaccountable for everything? And I do think that there are questions of levels and mitigation, but I don't think that it was presented in the right way. And I don't know that this is the forum to be having those weighty conversations in the trial. Um, what I can say as an outside observer who is able to be 50,000 foot objective, all of the experts on the defense's side seem to be ideologically motivated and unable to at least entertain the thought that there might be, if not, in their opinion, a moral, justification for the death penalty, but an understanding of why people might agree with it in this case. And I think that's maybe where the state or where the defense went wrong. I don't think that there was a way to do this that would not come off as offensive, and this was an incredibly hard case with the audio. But I do believe that there was a more, effective way to present this case.
the person that was in that van on November 30th of 2022. Tanner's problems began before before he was even born. And we know that child development begins in utero. So Tanner's mother drank alcohol heavily during that first 8-week period of her pregnancy. We also know that she smoked cigarettes. We also know that she smoked marijuana. And the result in this case was a diagnosis of fetal alcohol syndrome disorder. Now, FASD is a neurodevelopmental disorder that is characterized by emotional dysregulation, cognitive impairments, problem-solving abilities, and other issues. Now, how do we know that?
But not violence. And I think that if we clearly wanted to advocate for his mental health, the defense should have been incredibly clear that most people with these diagnoses do not have, a higher comorbidity for violence. They don't have those predilections. I can understand saying there is something wrong, but then to say, well, this exonerates him because 99.9% of people diagnosed with this don't do this, that's not the way you generally would look at this argument, I would think. I would think you would say he does have all of these he has all of these developmental issues, but he still knew right from wrong. Again, there is a way to give a full idea of how Tanner became the person that he was, what struggles he had, without it turning into a permanent parade of psychotic pity.
FASD is a valid diagnosis. It was supported by the testing. It was supported by imaging. You have the reports, you can read those. The fact that he was diagnosed with fetal alcohol syndrome disorder is uncontroverted. There are several phases to child development. We know that it begins in utero, but once you're born, you have to learn to explore your own world. Now, where does this happen? When a child is born, their parents are the world. From your parents, you learn love, you learn safety, you learn security. But what happens to a child that doesn't have all of those? Now, again, it's undisputed that his mother loved him very much. But did she have the ability to provide security? Did she have the ability to provide safety? She didn't. During this crucial part of his development, rather than providing him that security and safety, what did his mother do? Left a 10-month-old child, baby, with a 10-year-old cousin to babysit. Not just for a few hours, not just late into the evening, but overnight, and for multiple days at a time. Now, the babysitter, even at that young age, realized that something was just a little.
And again, I'm just looking at it from the strategical standpoint of parading your defendant, who is already going to be incredibly unsympathetic, his childhood in front of the jury when when again you're looking at. I just don't think this was an effective way to do this. I think that this was a guaranteed almost to provoke a negative reaction. And what bothers me is that both of these lawyers seem like they're competent and intelligent. So why are they doing things that are inherently detrimental to their case? That's where I get curious and wonder if it's an ideological adherence problem, a failure to kind of comprehend how they are going to be perceived problem, or something else. But I this is the part of humaning that I find fascinating. This is kind of my fascination, is why humans do illogical things. So I have learned to look at all the perspectives and try to see what's motivating that. But I am drawing a blank on it because they both seem like relatively intelligent lawyers, so I don't understand why they would do something that might be perceived as so incredibly crass and gauche, when they didn't have to, when there was a way to present better.
Little off with Tanner. He wasn't like the other kids. One minute he was running around like the Tasmanian devil, and at other times he would put himself in timeout and face the corner and be still. But the other thing she noticed is he liked to eat coins. She had to put him up on the shelf so he could not get to these coins. He loved to eat coins and then go to the bathroom, poop them out, and then try to fish them out and do it all over again. She had to hide the change because he was his own ATM machine. And that's important because
And again, I am not a doctorologist, I'm not a behavioral psychologist, but I would imagine because objectively, most humans have a repugnance for human waste. They just do. It's kind of inherent. It's a biological imperative that we were born with to keep us from getting, typhoid, all the sort of bad things that you can get if you have poo on your hands and eat with it. Most people do have an instant sort of just disgust factor. So there would be questions that I would understand. I would that behavior I would want more understanding on. Does he have a low understanding of, a a low sensitivity to certain things that other people find disgusting? Does he have low sense of smell, taste, or something that makes him somewhat immune to the things that would be a disgust kind of signaler? And coins aren't made with lead. Not that you should eat them, but I know they were going on the lead toxicity as well. Coins are not made with lead. Now, it seems super duper gross, but again, those would be the kind of things I would highlight from his childhood. These very odd, idiosyncratic behaviors that do show a maybe more drastically show up in his childhood. I would have highlighted some of those. But eh, what is this timeline?
according to the experts, that was also indicative of ADHD. Also, during this critical time period of development, his mother was in and out of the picture all the time. We know that she had her own issues. We know that she was in and out of jail. We know that she was in and out of drug rehab facilities. But that impeded Tanner's ability to have attachments. And Dr. Brahms talked to you about the importance of having a parent with whom you can form attachments. She talked about how important it was to have a parent from whom you can learn your coping skills. She talked about the importance of having a parent who could help bond and shape their behaviors. We didn't have this with Tanner's mother. She's a brave woman in many respects. She was brave enough to recognize that she could not provide for her son in the way that she wanted to. She had the desire, she did not have the ability. So she did the most heartbreaking thing that I think a parent could ever do, and that is give up her son to her mother to raise. And that was a very brave thing to do because she knew that Tanner would be loved by the grandmother and would be safe while she went to go to rehab to get clean. She also knew that she had legal problems and spent a good time in jail as well. Socialization. It's the next phase of childhood development. Socialization occurs when children are learning, basically.
And again, these are just pitfalls that you would think you would avoid altogether. Again, you would think you would be, this is not an unintelligent woman. So I am just so confused as to why she is constantly falling in these pitfalls that are of her own design. it's like when you see a really smart person. I don't know. It's just this is the part of me that it's like humans can't see these things. Okay, I have grown out of the phase where I hope that I'm an alien. I see myself more as an astronaut now. Anywho, it's just very confusing to see intelligent people constantly shoot, their argument in the foot and seemingly blissfully doing it, like, arrogantly and smugly destroying their own argument. Yes, I am in Indiana.
How to navigate in the world. And you look at it like when you're a baby and you're a child, again, your parents are your world, your crib is your environment, you have the safety of the confines of your own home, and then you go to pre-K, and then you go to daycare, and your world changes. It's a whole new environment. You don't have that safety net of your mom sitting next to you. You don't have that safety net of your wubby around with you. You have new experiences, new people, new things coming at you from all over the place. And if you are not equipped with the skills to navigate and to socialize, then that can impede your development. So we know that his grandmother had enrolled Tanner into daycare, Miss Diana's. And for the first time, Tanner had the opportunity to really socialize with children his own age outside of the home and outside of the family. But what happened at Miss Diana's? Well, Jackie watched as her only grandson tried to play with the other kids and was rejected, tried to have conversations and was rebuffed. He tried to make friends, but he wasn't able to, and eventually he would just go sit on his own. That was when it was suggested that Tanner get tested. And what was the result? That was when the family learned that Tanner had Asperger's. Jackie and Melissa took their son to a clinic in Fort Worth. And it was there that they had the answer that they had been seeking. Why is my grandson different? Why is my son different? They knew he was different, but just looking at him, can you really tell? But they knew he was just a little off, so they took him in. Now, Asperger's is another neurodevelopmental.
Well, and it's not atypical that, that 4-year-olds and 5-year-olds, especially boys, would engage in what, childhood development, professionals call parallel play, but not partner play, not interactive play. So with little boys, a lot of times, um, if you see them playing, if it's not an aggressive sort of combat sport, they're sort of playing next to each other, but they might not be interacting. And that's really typical for boys who are hyperactive or, just they don't boys are not as communicative creatures and social creatures as girls. So there are some things that with Tanner being as high functioning as he is, I wonder if it was seen first as ADHD, a very severe case, but still mostly ADHD.
Disorder that's characterized by communication issues and social interaction difficulties. Now, all of those you could see at Miss Diana's when he tried to play with the kids. Now, Asperger's is not curable. Once you have Asperger's, you will always have Asperger's. You may learn some coping skills and some techniques to control the symptoms. You might learn how to have good eye contact. You might learn how to engage. You might learn how to do other things to help mask your symptoms. But at the end of the day, you still have Asperger's. And now Asperger's today falls under the autism spectrum disorder. So based on this diagnosis of the Asperger's, or the ASD, Tanner received special services in school. And you met the school psychologist who confirmed the diagnosis. You met the fifth grade teacher who talked about the difficulties that Tanner was having in school. And you also met the speech pathologist who helped him. The next phase of development is what was described as the mastery of one's own environment. Now, mastery of your environment is the capacity to effectively manage and manage our lives. And it teaches us how to manage our surroundings. That's when we learn. But it's difficult to manage your life and manage your surroundings when you have no stability in the home. And again, it goes back to the fact that Melissa was in and out of the house. Melissa had and had not custody of Tanner. He bounced between schools. He bounced between homes. He bounced between caregivers. He even bounced between rehab facilities with his mother. That is not stability. He moved out of the safety and security of his grandmother's home into a drug rehab facility. And where was his dad during all of this? Well, we knew that his father had legal problems. We knew that his father was an addict. We knew that his father was in and out of his life as much as his mother was, if not more. But during this phase of development, that was when one of the worst things that had happened to Tanner occurred. When he was 10 years old, he and his mother were living on a farm, and he and his cousin set fire. They were playing, and this fire got out of control. Well, his mother
Thank you so much for the support.
Sent him down to the landlord to apologize for what had happened. So rather than accepting the apology and saying, no harm, no foul, I'm so glad you did this, thank you for apologizing, what did the landlord do? He anally raped Tanner. All because he accidentally set fire.
Now, I don't believe men. I don't believe women. I believe facts. And this doesn't ring true to me. And again, I have no problem if they were able to find the landlord, if they brought him in, if they wanted to do a Daubert hearing or anything of the sort to basically prove this. But Tanner's allegations, again, can optically be seen as a way to, again, make himself the victim. And it's the fact that many people have unfortunately, horrifyingly dealt with things like this in their past, as in their childhood, and do not go on to victimize anyone else because there is that inherent empathy, that inherent understanding that to do something like this to someone else would be the worst thing that you could do because you know how it feels to be a victim. You would never victimize another person. Tanner doesn't have that in him, and I think it's okay for the state to point that out. And thank you so much, Aaron, for gifting 5 memberships, and those went to Pan Williams, Star Z, Melissa Stassenman, Melissa Stedman, sorry, Kalaweo Alani, and Sheila O6T. Now, if I mispronounced any of those, and there's a great possibility of that, if you want to spell it phonetically, I will attempt to, I can learn. I may not guess it right the first time, but I can be taught the correct pronunciation. So congratulations. Welcome to the Church of Mo. I do have morning musings, and I am working on getting back on our book reading chapter or book club, for the love of Cheetos. Book club. This case, I'm just going to be honest, this has been the hardest case I've done as a YouTuber. And I think it's maybe in all the other cases, we don't know exactly what happened. We don't have a transcript. And unfortunately, just the facts in this case were horrific. And thank you, Sebastian Muller, for gifting 10 memberships. And those went to Donna Thompson, Scottish Cat, Tara Carissa, Chastity Danielle, sorry, Hipster Doofus, Paralegal Mind, Debbie Bennett, Ashley Ostroff, a Skeeter, and Gina Fitz. So welcome to the Church of Mo. We have dark chocolate and sarcasm, but we attempt to have open minds, not empty. We do reserve the right to be snarky at all times. Keep your hands and feet inside the ride, but it's going to get wild, you guys. How much longer does she have for the I do think it's oh, goodness gracious. Did she put the photo up? Oh, I am not liking that she's using the photo. Oh, goodness.
To a field. And we know that the records reflect that he had issues in school during that time period. The medical records.
Normally, I would say yes. And with Hagatha, the bad leg hurting me, and the artist formerly known as the good leg, I think I'm going to call it Gustav. I'm playing with Gustav, Hagatha and Gustav. Between the two of them, I would normally say yes, but this is a capital case, and we are pretend jurors, and we do have to the jurors have to sit through this, and at the end of the day, as much as we joke, as much as we're saying, let's have a 15-minute verdict, when you are a juror, when you're on that, 2-row panel, it's a lot different. And these jurors have a life that they have to consider. So I would imagine this is going to take 1 or 2 days, but we are going to listen to her because principles. We have principles, but we're going to be snarky and irritated about it.
Reflect that he had issues with hemorrhoids and constipation. All of those are indicative of that type of trauma. We also know that.
But that's also indicative of, again, medications and certain medications that might be used for hyperactivity. There is a side effect of dehydration and constipation. So much so that, all of my little boys have ADHD, and we have a supply of Miralax from their pediatrician, or recommended by their pediatrician. So again, it's the common knowledge that a lot of people are going to have nowadays that she kind of ignores. The basic everyday layperson logic where you can sit there and say, hey, no, my kid had ADHD and he was constipated because, that medicine made him constipated. Or it's just, asking the jury to ignore the obvious Occam's razor answer right in front of them without the extraordinary evidence that it would take to make me distrust my eyes.
He had difficulty admitting that and talking about it to the experts that were involved in this case. And that's not uncommon either. So after having suffered that trauma, Tanner transitioned into middle school, where he was still receiving services. Now, again, you met with or you heard from the in-home facilitator who tried to teach him social skills. And he was responding, did a great job. She loved hanging out with him, loved taking him out into the community, loved watching him develop. But she also talked to you about how difficult it was at home because, as much as Jackie loved him, she just wasn't getting it. As much as Bill loved him, his grandfather, he just wasn't getting it. As much as his mother loved him, she still wasn't getting it. And she and Melissa and Bill, none of them were allowed to continue with, and none of them followed through with any of the lessons that the in-home facilitator taught. And she said, he still needs him. But the school decided they were going to discontinue the services. Now, during your adolescence, you learn from Dr. Brahms that identity begins to form. And we shape our own identities. Remember back in high school where you experimented with different friends, different cliques, different hairdos? different clothes styles, looking for who you are and trying to find who you are.
See, and I'm a good person because that was a slow pitch. And because I'm Christian, I didn't say, and you landed on here where you decide to wear a demi cup bra on closing argument day. Again, as a busty gal, I say, flaunt them if you got them, but maybe not on closing arguments in a child case where your client is alleged to have SA'd someone. Yes, look, I am not a prude. I am totally for if you want to free the boob, you do you. But it's I am not focused. Well, I have ADHD and it's bothering me. A demi cup, basically, she just doesn't have a very full coverage bra, so she's jiggling at the top of her boob. A demi cup is basically half a cup. So demi, half, cup. So basically, it's a half cup, and the boobages can kind of bobble on the top. I'm giving away girl secrets.
This stage of development is especially difficult for one who has level 1 autism. Why is that? Because just looking at somebody, you can't tell if they're level 1 autistic. But the thing is, they know they're a little different. They know they're a little off. They know that they just don't quite fit in. They start to see themselves as an outcast. They start hanging out with other people that they identify with, other outcasts, and it becomes that self-fulfilling prophecy. When we talk about identity,
Ma'am, Demi Moore is not coming in. This is not Quasimodo. God save the outcast. I agree with, but no.
we have to ask ourselves, what is it like to be Tanner Horn? And Tanner described himself as being an android when everybody else is an apple. And he feels like a robot, but that defaults to human emotions. And that's important because it shows that he recognizes that he's just a little different, but
My stream couldn't take it anymore. It was like, no, we just don't. And honestly, again, I say this legitimately as a child who got through middle school because she desperately hoped that she was an alien from a different planet and it was like an ET situation. And I got left with the weird humans, Jane Goodall style, and my family was coming back to get me. So this seems like an extraordinarily bad take when feelings of isolation and otherness are somewhat ubiquitous in middle school, regardless of whether you're neurotypical or neurodivergent. It does seem to be that, again, these would be kind of universal feelings that um, would Venn diagram with autism, some of those kind of same alienation and lack of identity, lack of fitting in feelings are not so out of the realm of possibility that people can't empathize and understand them, but we haven't gone on to be violent to other people. That's where this whole argument runs afoul of logic.
to fit in. The other thing that Dr. Brahms talked about was how important it is to have someone in your life during this critical phase that can encourage you, that can recognize your successes, give you that positive feedback that you want and that you need. He didn't have any of this. Again, he had a mother who loved him, but she was struggling with her own issues, the legal problems, the drug addiction, her own personal trauma. He had a grandmother who loved him, but she was also struggling with her own personal traumas, the traumas that she herself suffered, the traumas that were inflicted upon her daughter that she harbored such guilt for. She also had her own physical health to contend with. The last phase of childhood development that we learned about was emancipation into adulthood. And that's where we talk about where we have developed coping skills to become the integrated adult that we are. Now, what do we mean by an integrated adult? Well, that means that be able to absorb what is around you and take that in and make your decisions based upon what you've learned. No one at home taught him how to do this. He had no coping skills. His default became avoidance. He avoided everything. He deflected to music, to anime, to movies. And he never learned to deal properly with the stressors in his life. So we talked about interventions. And it's no doubt that Tanner had a lot of interventions. He had the speech pathologist during middle school. He had the content mastery teacher in high school. He had Beth. He had his fifth grade teacher helped him out. But remember what you learned is that if you don't continue with these interventions, use it or lose it. He didn't have anybody at home that could help him use it, and so you just kind of fall off. And it's also important to note that high school content mastery, it was available to everybody, and it really did work for him. It helped him graduate. Now, granted, he graduated in like the bottom 5% of his class, but he went on to graduate. After he graduated, things kind of drifted from band to band, from job to job, and then he met the mother of his child. They fell in love, moved in together, and they had a child. But moving in and having a fiance and having a baby isn't the same as settling down. They moved around a lot. They still had a lot of chaos in their lives. They bounced between her mother's house, his grandmother's house. They lived with friends. They had their own apartment, all these different things. So there was still chaos in the life. They also had financial difficulties. We know that the mother of his child was suffering from postpartum issues. She wasn't able to work, wasn't able to keep the house, wasn't able to do all the things that she wanted to do.
And that's where Tanner, as an adult grown-up man, if his partner is struggling, then he picks up the slack. I think it's my criticism has all been in the tone, and I think she and the other defense attorney have tonally crossed the line. More in more it's my upset with her is more the confusion as to why she is arguing so badly. And fair point, Aaron, they have limited I will tell you guys, I shouldn't be arming myself during today, but this is, look, I don't know why Japanese stationery is so awesome, but they have Sailor Moon wand stationery pens that also become Mortal Kombat weapons should my boys find out that they do this. So I never do this around them. But I feel like I need now this is Sailor Uranus's. For some reason, it feels like Uranus should be the meter of justice in this case.
Except go out and party. And we know that that's what they did, even though they were trying to save money to buy a place of their own. So Tanner was trying to be the only breadwinner, keep his fiance happy, save up to get the place of their own. So they never could seem to get ahead. They always had these issues. And then the car that they had broke down, so they had to get a new car.
Did Tanner ever go without cigarettes? Did they ever go without door dashing? Again, there is poor and then there's poverty you bring on yourself. And that's kind of where I think the compassion fatigue gets a little more pronounced. I maybe wouldn't I would have glossed over this, but to bring in all of this, he's trying to be the man of the family, and then to see how disgusting there are basic human things that he could have done that were not beyond his means. As a neurospicy person, again, as a person who thought it was completely normal to imagine yourself as an alien until this trial, legitimately, I am not shitting you guys. I have never wanted to call a mental health professional more than when I was like, "Wait a minute, he thinks he was an alien? I have always thought I was an alien." I feel confused. So legitimately, I'm not I'm saying that I have often thought that this way, and yeah, I could have done without learning his own personal ATM. We could have left that out.
Kept rolling and rolling and rolling, and his boss came in and gave him $1,100. But that also added another layer of stress, because now Tanner had to work 6 days a week in order to pay that $150 a week back. When he took the job at FedEx, he thought that would give him some stability in life. That's what he was hoping. And for a while it did. They still had the money problems, and they were working through all of that. But he had the root nasal. That's where he grew up. He knew those streets. He was able to do his routes without issue. And then his route got changed. Added another layer of stress. Another layer of stress that he was not able to cope with. When the route changed, the anxiety increased. New routes, new roads, new people, new routine. And that's
Now, what's odd is that the defense has actually done more to prove to me that Tanner would not be suitable for life without parole, based on based on the way he reacts to increased stress situations. The defense has made incredibly clear. In fact, they've hammered the point medically over and over again that this man cannot handle stress, that he reacts violently, or at least that's a potentiality of the logic trees of what he does. Um, uh, I do not know. I tend to, especially with kiddos, not do a lot of digging. Now, from just things that I've inferred from the trial, so take it with a grain of salt, it seems as though for a period of time prior to the incident and then following and continuing on after the incident, due to both Tanner and the child's mother being unable to adult, the maternal grandmother has had custody of the child. She is an RN and was apparently deemed fit enough to have custody of the child. I do not know where that stands now. But that's what I gleaned from at least all the information that's kind of come out in trial or been alluded to.
what led up to this offense. We don't forget Athena. We don't. Because on the
If this had come from the other lawyer, I think it wouldn't rub as raw, but I don't think she is the one that should have done that. Sorry, it's always when I'm taking a bite of something.
November the 30th, 2022, Tanner did something that changed the lives of all of us. Every single person in this room has been affected by Tanner's actions. On that day,
And I will say as a mom, I will say as a mom, blessings and prayers on the mom and bonus mom in the crowd, because I don't know if I could have handled it. Look, I have held my peace the entire time, and the fact that she touched something that had my daughter's face on it after, again, I understand the constitutionality of what she has to do. I understand that on an emotional level as a mom. If you have spent, again, as you're supposed to, your entire time making the fact that no one has jumped up, because my self-control would be frayed.
Tanner delivered the packages to Athena's house, Barbie's. And he got out, delivered the package, decided to snort a little cocaine because he had had insomnia, was tired, was, had all these other issues. And she saw him, and he thought that she was going to tell on him. And if she told, he would lose his job. If he lost his job, he would lose his car. If he lost his car, he wouldn't be able to have transportation for the baby. If he didn't have transportation for the baby, something could happen. He couldn't do this. It just kept snowballing in his mind. Now, there was no planning. There was no premeditation. There was, no preparation. You kept hearing.
Again, the defense, do you understand what you're arguing now? I'm a very logical person. You have now told me that he will not plan, but be incredibly violent. So I can't even predict if he reacts negatively to stimuli, if he reacts negatively to any change. I can't even predict what changes might bring out this violent, erratic, behavior from him. Do you understand how you are completely negating your own argument? All of the evidence you have put forward has actually been more convincing than what the state put out at the fact that Tanner will never be able to, by bent of reality and biology, ever be fully trusted if the situation is not completely structured. Because he can, without prediction, without predictability, without any sort of, warning, become incredibly violent without planning. Do you understand what you're saying? Again, this is the problem I have with the defense.
About all of these stickies being put on the lens cover. But let me ask you this. If you were planning to abduct a child, would you cover the lens cap before you did it or after you did it? It doesn't make sense. And that's
Legitimately, are you a plant from the state? Because I can't imagine the prosecution wanting you to say anything other than this. The prosecution is licking its chops. If you wanted to save Tanner's life, you are doing everything to make sure that this man gets charged with a death penalty. So ask again, are you a plant from the state?
where their assertions fall apart. It does make sense that he would have covered a lens cap to hide the fact that he was vaping weed. It does make sense that he would hide the lens cap or cover the camera lens if he was snorting some cocaine. It does make sense that he would do all of that, but it doesn't make sense that he would wait until after she was in the van to cover the lens cap. All of this was caught on video and audio. And like I said, there is not a person in this room that heard that was not deeply affected by that. We all were, and we all will have to carry that with us for the rest of our lives.
And then you proceeded to put on the case that you did that was so tonally off base that it looked like direct disrespect, compounded and exponential disrespect to the evidence and the facts in this case. Do you not understand?
No one should have to go through what Maitland Gandy and Jacob Strand went through. No one should have to bury their child. And when a child is taken in the way that she was taken, it's natural for us to be angry.
This is what you should have started out with. This is the hook that you have. It's natural for you to be angry, but we can't decide this on anger. We can't decide this on feelings because that's not how our justice system works. What we can do is look at the evidence. Did the state prove to you that Tanner was covering up the camera because he was hunting? Or is that just a piece that fits perfectly into their narrative? What proof did they have that he was actively hunting? Could it be, just like we said, that he was hiding drug abuse? That's how you do this closing. And I'm a twice college dropout. If I can figure this out, what the heck is wrong with you, ma'am?
We should be angry. We should be furious that her life was taken from her in that manner. We have every right to be, and we should be. And it's natural for us to want to know why this happened. But you know what? we won't ever know why it happened. It's easy to sit here
Because your defendant is a coward who wanted to negotiate giving the truth.
and blame the autism, the lead exposure, the FASD, the ADHD, the mental health issues. It would be easy for us to do that. And the state keeps telling me that that's exactly what we did. But remember, every single witness that we asked, is this an excuse? This isn't a defense. This isn't.
Except that you can say that, and that can be your thesis statement, but when every action, when every expert, when every, thorough line in your case is an excuse, is an advocation of his agency, when every expert, ignores the fact that he decided willfully to take hallucinogenics and things like that, well, he was stressed out. When he willfully decided to quit jobs or pick jobs that were not going to be structured or, probably appropriate for his diagnoses. There were a lot of things that Tanner had control over. And I think that the defense, by playing Schrodinger's autistic, by trying to simultaneously say that he was so, so so non-functional that he was basically a level 3 at some points when they need him to be, and then a level 1 or above when they need him to be emotionally understanding and a responsive partner. That's the part that doesn't work. And again, why would you go into court on a capital case with such a fundamentally flawed argument?
The justification, and every single one is like, no. The fact that he has autism is not an excuse for killing Athena. The fact that he has fetal alcohol syndrome disorder does not excuse the attempted sexual assault. The fact that he has lead exposure does not excuse the murder. It is no excuse. It is not a defense. It is not a justification. But what all of these diagnoses do is it kind of helps explain how we got to this point, how we got there. Now, the state wants you to believe that unless you're sitting in a corner drooling all over yourself, you are not impaired. But every single expert in the field said level 1 impairment is still impairment. Mild is still impairment. Moderate is still impairment. You just aren't a little pregnant. You either are or you're not. You are not a little autistic. You are or you aren't. You are not just a little alcohol exposed. You are or you aren't. There is no, if you are, you are. So the important thing to remember about these diagnoses is that they are not what we call additive. It doesn't mean he has autism plus FASD plus lead exposure plus ADHD plus mental health. That's not how it works. All of the experts testified that this is a compounding issue. So it would be autism times FASD times ADHD times lead exposure times all the other mental health issues. And so it doesn't boil down to.
And here's where I think that she could have made an argument. Again, these are things that maybe the jury wouldn't have thought about, and she could have zealously put those things out there. I I am legitimately confused. Things like this do boggle my mind. It's kind of why I always thought I was an alien, because I see the logical pitfalls that so many people have, and this started when I was 9. I was a weird child, okay? Um, and yet we cannot seem to get in front of ourselves because emotionally we are tied to something. And while I say I can be completely objective, with myself as well, I still have an emotion, so I'm confused all the time.
Well, you had bad upbringing. You didn't kill anybody. Well, Did that person also have autism? Did they also have FASD? Did they also have ADHD? Did they also have lead exposure? So we have these false equivalents.
Now, what I will say that I have found comforting is that a lot of people are not buying this as an excuse. Now, whether it is because of the type of integration that the school systems have been working on for the last 20 years, since the early 2000s, where more people with autism were integrated into, normal classes and given, adaptions and physical therapy, occupational therapy interventions at an earlier age. I do wonder if now, because this is not a sort of someone else diagnosis, with the prevalence of it, we all might know someone in our lives that maybe is high functioning, would have been classified as Asperger's, or maybe little less. We've all run into these to people with a diagnosis like this, and we've all realized that, yeah, we've never felt creeped out. We've never felt anything weird. With Tanner, there's something missing. It's not autism, it's something else. You can tell us he has autism, but the reason he did this, you're right, is not autism. It's not an excuse. But I don't think the autism explains it either. I don't think I really don't think it's an explanation.
Going on throughout the state's questioning. It isn't a false equivalent. It is a compounding issue. So, again, what does it all mean? We know that Tanner had a history of catastrophizing. We know that. And in the most simplistic terms, it's making a mountain out of a molehill. And when he thought that Athena saw him doing cocaine, it never dawned on him that she wouldn't know what it meant. It never dawned on him that she might not recognize that what he was doing was wrong. In his mind, he jumped from point A to point Z in the most irrational fashion. So somehow somebody, a child seeing him.
Again, defense, how does this make me any more convinced that he is not a present and continuing danger? He goes from 0 to, 900 illogically. You are making a better case than the state did that he will continue. And again, by dint of biology, by dint of his very own making, down to the DNA, will always be a threat. I mean, maybe I'm just reading this wrong, but this is how I'm reading this, and I don't think she understands that this is how look, Thor, we have talked about this. Stop with the mic.
Do something that they may or may not understand, ended up in him losing his child, losing his car, and being evicted from his house. So that's how his brain worked. And once he made the decision, the very bad decision to take her, it just snowballed out of there. He didn't know how to get out of it. He wasn't able to reason and think about the consequences of his actions. And again, that's not anything new, because you heard from the...
Again, this is argued. He was able to... Sir, he stopped at a secluded place. He didn't stop to attack Athena right in front of her home. He didn't go out into the field. No, he logicked out and decided that a secluded place that he had pre-looked at would be the best place. He dumped her body in a place that he was quite familiar with and knew wasn't going to be heavily traveled during that time. These were not, panic. These were not, oh my God, what am I going to do now? This was premeditation for someone who has low processing power. This is the height of his mental maturity.
Teachers who recognized that issue all the way back in 5th grade. So this isn't something that the defense cooked up to try to get him out of it. No, we have the documentation from it. And you have those records. You can look at those records. You can take every single bit of evidence back there and go through it. You have that right. Just ask the judge to send it back with you. The catastrophizing isn't new either. You saw that also through many stories that you heard from the witness stand, especially the one where, they talked about him losing his patience over at Outback over the dishes piling up. He was overwhelmed and wasn't able to cope. So rather than asking for help, which
Sir, we've talked about
we
it, not
kind
the
of
face.
would probably think the normal person would do, no. He became overwhelmed and he quit because he couldn't handle it. And we talk about these diagnoses and how they are presented. Well, they were on full display during the interrogation videos. Full display. Dr. Brahms told you that every fifth sentence in those interrogation videos were diagnostic for her. Now, we know that he lied. We do. But as Steve pointed out, lying goes back to the dawn of time when we've tried to cover something that we have done wrong. It's not anything new. Officer Amy lied to cover her tracks. Joe Espinoza lied to try to get a confession. We have, to say that because he lied about the multiple personality disorder should discount everything else we know in this case is just a bunch of hooey. What we have to ask a question.
Thor officially sneezed at her use of the word hooey. What in the shenanigans laden hell? Like, I can't go in all country, but the fact is, the state prosecutor can somewhat pull off the old sort of preacher, look, I'm not going to brimstone you. I could brimstone you, because that's how he started out. This woman has not slipped into country kind of colloquialisms. This hasn't been an authentic thing that she's done. Now, you could have. But the prosecutor has done this throughout the trial. So this is about as authentic as Hillary Clinton going like, I carry hot sauce in my purse. Like, this heifer doesn't know the difference between Tapatio and Frank's, okay? It's just very jarring, and it doesn't look authentic. It looks put upon. It's just another, it looks like you're being sleazy, like you are pulling out every, trick you have to try to persuade them. At least to me, and it is jarring if you are like me, are a very audio learner. You do start to develop patterns and kind of cadences, and you recognize a person's sort of speaking patterns. So when they go completely off, yes, Thor sensed I was in a black shirt. Um, it's very jarring and it pulls you out. It doesn't punctuate uh, like it would if the state prosecutor did it, because it seems authentic, it seems baked into him. This very much seems put upon.
The question we have to ask
Stop with
ourselves
the
is,
no, we
was
talked
this
about this.
lying
The printer doesn't love
manipulation,
you.
or was it just a way of enabling himself to confess? Did Tanner actually confess? Yes, he did. But he did it in a different way. He took on the persona of Zero to enable him to make that confession. And we know that it's not uncommon.
Oh, dear Lord, do not let Amber Heard figure this out, because her alternative, personality pledged the donation. Don't let Laura Owens figure this out either.
For people with autism to speak about their person, speak about their brains in the third person, because it makes them easier to talk about their issues. It makes it easier for them to admit to things that they're embarrassed about, that they're ashamed of, that they're afraid of.
We've got about 2 more minutes.
But at the end of the day, was there a confession? And I got to ask you this, and we asked one of the witnesses, I can't remember which one, but we asked, did Tanner really think that he was fooling anybody by adopting that persona? I mean, Ranger Espinoza wasn't buying it. I don't think any of us was buying it. But,
Again, and this is just a mild critique, but the jocularity, it's shocking. As someone who finds more comfort in logic, and the way she's kind of jumped from emotion to emotion to emotion, anger, we're all mad about Athena, and then, but he, feels sorry for him, and then she's like, "But did you remember that, do you remember that funny time when my client lied to the police and pretended he had, multiple personality disorder? Wasn't that a stupid thing to say?" No, he made it so that a family had to wait 8 more hours to learn if their child was coming home or not, and sadly, it was that they were not coming home. So there is that that pitfall that if you inject any jocularity into this, you could trigger people's memories into what that jocularity was aroused by. Again, i.e., the evidence of the fact that Tanner was making up a boogeyman in his head, from his Christian punk rock band or whatever screamo thing he was doing, in order to, abdicate responsibility.
due to Tanner's lack of theory of mind, he was not able to perceive that the other people were not buying what he was trying to sell. And again, at the end of the day, he confessed to the crime and eventually led the officers to Athena's body.
Yeah, you don't get a W-2 for 10% of a half-assed job. That's all I'm gonna say.
Thank you. Now, during jury selection, we talked about, what was important for you to hear in order to make your decision. And we heard responsibility, remorse, rehabilitation. Well, responsibility, Tanner confessed. He confessed to the offense. Responsibility, he stood in front of you and entered a plea of guilty. He entered a plea of guilty knowing that the result would be he would spend the rest of his life in prison. Remorse. Yeah. I remember when my mother passed away, I was angry at everything. I was angry at the world, angry at God, angry at my
I I think that the personal approach was more appropriate in the Corey Ridgens trial, to maybe pass on the perspective of a grieving widow with small children, especially because the defense attorney had gone through that, and personally, because I've walked through something similar, it actually made the defense attorney in that particular case more human to me. But everything about this has been as tonally right as a pride parade in the middle of Mayberry. I'm not saying that there's anything wrong with Mayberry or a pride parade, but I am saying tonally, that's what I feel. I feel like I have taken a Quaalude and the timeline is completely wrong. How is an educated person this bad at this?
family, because I didn't think that they were grieving the way that I thought they should grieve. So I went to church and I spoke with my priest and we did a little grief counseling, and what he taught.
Are 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 is she saying that society is judging Tanner's remorse too much on the straight and narrow, and we need to, account for his neurospiciness? Again, at what point are you advocating, or are you taking away agency? At what point? Because to be a sentient, thinking human, you have to be able to make your own choices, master your environment for good or for bad. At one point, does Tanner have agency over, his brain, however different it is? How when do we allow that brain or give it credit for functioning at whatever capacity?
Taught me was that everybody grieves their own way, and it's right If it's right how you grieve, it is right. It's the same thing with remorse. If we all show remorse differently.
No, atonement, I guess could be a personal thing between you and your salvation or your creator. Remorse tends to be and usually is quite patterned in societies. We are social creatures. There are usually steps like genuine show of understanding of what you did. These things are usually a series of steps that go from remorse, atonement, all of those things. No, Tanner, it's not Tanner's truth. It's not Tanner's remorse. Oh my gosh. Ma'am, the limbo bar could not go lower. I mean, Hermes from Futurama can barely get under by now.
We do. And just because it's not shown in a way that you want it to be shown doesn't mean that it doesn't exist. And let me ask this question. How does a person with autism, where one of the characteristics is they are not able to express their emotions, how do they effectively communicate what those emotions are?
In a genuine and authentic way. There are a lot of people that maybe don't have eloquent words, maybe don't have, things, but there are ways to even non-verbally express remorse and atonement and wanting to be seen as a member of in good standing of society again. Uh, we are in fact such a social species. There is such a pattern to this that major religions have entire ceremonies and steps where you have to go through cleansing and purification and all sorts of steps to again outwardly show your internal remorse and atonement. That is what we require. It can't be Tanner's truth.
In a way that is satisfactory to the world around him. Well, you saw the remorse in Tanner. You saw it on the interrogation videos. Even Ranger Espinosa noted that, I see the remorse in you. I believe you're remorseful.
Ranger Espinosa is allowed to lie, ma'am. You started your entire argument thesis statement with that. Well, no, you didn't, but baby Huey did. So he did make a point to remind the jury in the opening of this argument that Ranger Espinosa can lie in interrogation. So that is not the point that you think it is.
You saw it in the suicide note that he wrote when he had nothing left to lose. And he had nothing left to gain at the time. He apologized to the family for what he did and expressed his regret.
No, he apologized to the family for what FedEx made him do. There's a very different way that that was written. And, ugh.
And remorse. You saw it in the face when the video of the incident was replayed. Again, just because he may not express it the way everybody else does not mean that his remorse is not there. Rehabilitation. You heard about what he did in jail. You did. You heard about all of the courses that he took. You learned about the fact that he found God again and that he wanted to help his other inmates find God. And that was his new purpose. He reached out to Chicken and they started a Bible study, even though they had to talk through the bean chute, even though they couldn't share their own Bibles with each other. They had that Bible study and it was important to him. The note that Chicken wrote him is in evidence. I encourage you to take it back and read it because that was written by a man who wanted to express his gratitude for helping him.
By a man who did not know the charges to which Tanner was pleading guilty. Again, there is a very clear evidence in his tonal shift that he was not aware of what Tanner did. That he had been given a very cleaned up story. And when the state said, was this about the death through, blunt force trauma of a little girl? Do you understand that? And he was like, do what now?
Him find God again. The things that in life that created deficits for Tanner in the real world are the things that are going to serve him best in prison. Structure, clearly stated rules. And we know
Has this woman ever been in a prison? The type of structure that a person, an inside Cadian like me, would need is quiet, people not in my space, people not trying to talk to me, people leaving me alone. None of that is going to happen in prison. So have fun with sending him to general population. I am not worried about it.
that structure worked for him because it worked for him in school. You heard that from the teachers. It worked for him when he worked for Jason. You heard that from Jason. It worked for him in Wise County where he had no disciplinary actions. It worked for him in Tarrant County where he had no disciplinary actions. The only time when he didn't have the structure in his life, he flailed and he failed, and that's why he's sitting in the defense chair right now. You know, the decision to end another human's life is a deeply personal one. And each of you was selected to be on this jury because, you know, you promised us that you would follow the law. You promised us, you promised the judge, you promised the state, you promised us that you would follow the law, regardless of where the evidence took you, regardless of your personal feelings. You promised you would listen to all the evidence and you would hold the state to their burden of proof. But now's the time for you to fulfill the oath that you took. And the state of Texas never requires a death sentence. Not in this case, not in any case, not even in the worst case you can possibly imagine. They're always satisfied with a verdict of life without parole. And you are going to be tasked with answering special issue number 1 and special issue number 2. Did the state prove beyond a reasonable doubt that Tanner Horner is a continuing threat to society? No, they didn't. In fact, evidence to the contrary, it's uncontroverted that he has adjusted well to jail life. It is uncontroverted that he has no disciplinary actions. It is uncontroverted that he has been allowed to have access to all of these people in the jail without incident. But if you answer yes, that only makes him eligible for the death penalty. It doesn't mean it is automatic. And that's where we get to special issue number 2. Mitigation is any reason for any one of you to choose life. And it can be individual for each of you. That's why we talked about your individual moral judgment during jury selection. You have the absolute right to pick and choose what is or is not mitigating to you. And if you have found something that is sufficiently mitigating that would warrant a sentence of life without parole rather than the death sentence, you have the absolute right to vote your conscience. You have the absolute right to have your voice heard. So when you go back in that jury room, what I want you to do is I want you to talk to each other. And y'all have been talking for like the last 5 weeks. And what's a little more talk, right? I want you to talk to each other about your lives, about your experiences, about the things that make you who you are. Talk about what you saw. Talk about your children. And then
That's very, it's a double-edged sword because there could be a single juror on the stand who, is going to picture Tanner as a little baby and may not be able to make that choice. But it's also incredibly risky to bring people's children into this because it's such an emotional thing. I have admitted I've been having a hard time being unbiased because Athena looks very much like all 3 of my little girls did. It was a hard time to do the reporting on the father who took the lives of his 3 little girls up in Washington because they looked very much like my little girls did at that age. So there is that potentiality of making it personal when the person on the jury is intending and attempting to be as logical, as bound by the law as possible. But she seems to be just pulling out all the stops.
what I want you to do is speak up. I want you to speak up. If you have a reason to choose life, speak up. Because that is your right. Your truth is your truth, just like your other jurors' truths are their own truths. I don't envy you. I can't imagine being in your position and having to make this decision that you're about to make. It's probably going to be one of the most important decisions you will ever make in your life, because you hold a man's life in your hands. And your decision, it'll define who you are.
And she's also pointing out, paradoxically, again, the pomp and circumstance that Tanner's life is getting that Athena's didn't. Athena didn't get, a month-long trial with 6 to 7 experts with more than, $500,000 spent. Athena got no judge, no jury, no bailiffs, no social media accounts, following the every move in the trial. She didn't get that. And again, she is pointing out this very big dichotomy, and I don't know if that's a good idea. Again, a lot of people might not see it that way, but this is not very good, in my opinion.
Are you going to be merciful? Are you going to be benevolent? Are you going to be vengeful? Because mercy isn't earned. Mercy is freely given. That's why we call it mercy. Then ask yourself, do you really stand for life? And if you can answer that question, then I want you to raise your hand, and I want you to vote your conscience, and I want you to vote.
Again, using the religious angle, and I see where she's trying to prick that pro-life, maybe what she's assuming is a very conservative, probably pro-life sort of thing. That's the problem, is that the Bible does not preclude you from justice, from actual, adjudicated justice. The Bible doesn't really say anything about that. In fact, the Bible has many examples of capital punishment. So to go to an authoritative state thing like that, again, it's this very, very confused understanding of Christianity, because you don't respect it, and you look down on people that have those values, that you think you can just pull out the pro-life card and say, well, you say you're pro-life. No, no. Just like you were talking about mental health, religion and the Bible can tend to be very nuanced. It depends on your interpretation. It depends on your school of thought religiously, your denomination. So to blanket assume that just because you are in a rural area that's more conservative, that you can throw out a pro-life, well, I dare you, are you really as moral as you say you are, is not the route I would go.
For life. And that's why we are asking you to sentence Tanner to life without the possibility of parole. Thank you.
Mr. State.
Thank you, Your Honor. You know what else you hold in your hands? Justice. That's what you hold in your hands.
That was such a slow pitch. Again, she had to know that he was going to come out swinging. She had to know, is she a plant? Is she a plant? Does anyone have any other cases this woman and her organization have done? Because I am beginning to feel like, I feel like Sheldon. I don't get it. Why are humans so weird?
And I want you to ask, is Tanner merciful? Is Tanner vengeful? Does Tanner show remorse? Nope. And I think that's important. Talked a little bit about adjusting to jail. You know what? I fully expect somebody who's staring down the barrel of you sitting here as a jury would probably act right while they're in jail. Well, how did he act when he didn't have that? How did he act when he didn't have that incentive? It's right here. It's right there. That's how he acted when he didn't have that.
This prosecutor has been incredibly restrained. The gloves are off now. The gloves are off because, again, this is all she wants to talk about compounding. After that audio evidence, anything that is seen as disrespectful or irreverent or jovial or jocular about the victim, about this case, is going to seem exponentially, compoundingly awful. And your complete disrespect about what was lost, not by your words, but by what you presented. And if you don't understand that you have to pay more than lip service to your thesis statement, then I can't help you.
So when you want to say he's rehabilitated, he hadn't had access to anybody else. And I believe giving him access to anyone else in life in prison is a mistake. He should never have access to hurt anyone again, ever. Now, we talked about whether or not Tanner showed remorse, and I don't really know why we need a psychologist and a bunch of excuses to explain to us how someone shows remorse. I mean, was remorse to lie? You want to use the suicide note? Well, it said, yeah, I'm sorry, but it said, well, I'm going to throw out a whole new theory out there for the family to cause them more pain. Make up another story that they're going to have to deal with. That somehow remorse? I don't even know what the word that lady used. I can't even spell it. But if you got to have a degree in
And again, this is where the authenticity comes out. He has always been, I'm a country lawyer. That's kind of been his shtick. It's a way to sort of weaken the defenses of nervous witnesses. You know, shucks here, I'm just a lawyer. But also to maybe bait and get the defense's experts to underestimate him when he has an incredible understanding of his subject matter. This comes off as authentic. The darn tootin' and rootin' tootin' and no siree of the defense when she peppered him in there just sounded is so incredibly cringe.
psychiatry and psychology and use a 12-letter word with an X in it, I really don't think you're really remorseful. You know, I dug through some stuff. Has a bunch of reports, notes, everything. It came right over here. Everybody, how many 100 hours? 100 hours or more? How many psychologists, how many experts? You know what you won't find in this box right here? I'm sorry. Not a single time
Incredibly powerful.
in this entire box. Now, what this entire box is full of, it's all about Tanner. He's more than happy to talk about his life, more than happy to talk about his problems. He's more than happy to talk about that. But you would think in 100 hours, you would think all those experts somewhere, someplace, one single time, stop what you're doing, quit talking about me, and just say, I'm sorry. I don't think that's too much to ask, but you can dig. It ain't in there. Now, Vince wants you to give him credit, if you will, for coming in here and pleading guilty. I think it's bigger than that. I think if people are truly remorseful and people truly take responsibility for their actions, truly,
Fair
then those
point.
are those.
But this is argument, and he is allowed to try to marry his narrative to the facts. And the defense was just as loose with factual evidence and what she was stating and how she was stating it. So if it's right for the goose, it's right for the gander.
People that we should talk to about that. But that's not what we have here. Not in any form or fashion. We have an individual that continued to lie and make up stories all the way through January of 26. That is not someone who's taking responsibility for their actions. That is somebody who continues to lie, divert, and is attempting to continue to change the narrative about themselves. Now, this whole catastrophe theory, if you really believe that a 7-year-old girl knows what it looks like for somebody to be doing blow on the hood of their FedEx truck, that's crazy.
I'm just stopping there because he said doing blow on the hood of his FedEx truck. And I did not have that on my bingo card at any way, shape, or form. I do love the subtle petty when it comes in. And on many other cases, that is where I shine. I love that. I have a little salute. But I do love the very dry, sardonic wit that this prosecutor has.
The simple truth is that's another lie like anything else. And you know how I know it's a lie? Because once you find out that we've got you dead to rights, you make up another story that fits your narrative. This fits his narrative. Just like everything else, just like every other lie. But you know what the problem is? What the problem with this whole catastrophe theory is, the expert up there, Dr. Ryan, Ms. Anderson just did the same thing. You said you went from A to Z. Wait a minute. Did he go from A to Z? No. He didn't. He said, you're pretty. Take off your shirt. Take off your clothes. That's not A to Z, stopping off in the middle to sexually gratify yourself on the child you just kidnapped. That's not catastrophe. That is a true predator. Someone who stripped a child away from their home, took pleasure in sexually assaulting them, and killed her. That is not catastrophe. Because that's the whole thing. That's why every expert up here ignored that one part. That's why Ms. Anderson ignored that one part. Because you can't explain it with catastrophe theory. You just stopped off in the middle of your catastrophe and did this. That's not what we're talking about here. That is true evil, is what that is. Now, we talk about these interrogations. I don't know how much nicer that Ranger Espinoza could have been. I don't know how much more friendly he could have been. And I don't know why we continue to try to excuse Mr. Horner's conduct. Clearly, he thought he could come in there and make some kind of deal. But let's look at the bigger picture here. Let's look at all of this. What is this? It's selfishness. It's internal selfishness. It's nothing to do with her. Nothing to do with her. It's all about him. It's everything that's in that box. It's all about him. That is selfishness, is what that is. Is that he is coming there and he is saying, hey, I'll tell you what you want, but you got to give something to me. And I want something. I want to see my kid. Where'd Athena spend Christmas? She get to have videos with Christmas that year? Nope. Now, we keep talking about excuse, and we keep hearing people tell me it's not an excuse, but I hear all of this stuff that's going on led up to this offense. All of this stuff that's going on supposedly in his mind led up to this catastrophe. All of this stuff that's going on because he had stress from work. He had a change in routes. All of this stuff led to something else. That's simply saying, yeah, I did it, but, and that's the key. I did this, but hey, look at this. That is the definition of somebody trying to excuse their conduct. And I'll be honest with you. One of the things that really got me fired up in this case was there are thousands of people in the world. We know them. They're sometimes our friends, our family. Thousands of people in the world that have disabilities. Thousands of people in the world that are autistic. And they get up every day. They live their life. They work. They have families. They struggle. They succeed. And they fail. But the one thing they never do is use it as a crutch.
Your Honor, we would object. The state is trying to create a nexus between the mitigation and the offense, which is not allowed.
Overruled.
Hey, Aaron, I would like your interpretation on that because I know you are a lawyer and you you are seeing things different. So I would appreciate it. And this is one of those times where I am not being sarcastic. If my voice or face appears to be sarcastic, I am being genuine.
How much longer do we have a juror that needs to take a break? How much longer do you anticipate Pete? Not trying to cut you off.
How much longer do I have?
You got about 25 more minutes.
I got you. I got you. Let me end with this. When we talk about two things, future danger. Every single expert that got up here, every single one, told you they would have never predicted this. They would have never predicted he would have hurt this little child. They would have never predicted that he would have sexually assaulted her. They would have never predicted this whatsoever. They were wrong. Absolutely wrong. And every one of them admitted it, that they were wrong. So anybody who comes up here and tells you today that they can somehow predict the lethality of this man at a later date is wrong. Here's what we know. We know he has a capacity for maximum violence. He has a capacity for victimization. He has a propensity for sexual assault. Now, all of those we know. I don't need an expert to tell me that. I can look at the autopsy report. I can look at the pictures. So when you talk about future danger, look at the facts. Look at what he's capable of. Look at what he's done. And don't think that there's not some other victim out there waiting. Don't think that. If you think, this is the way I think about this. If you put a man-eating tiger in a cage.
Aaron says, I thought it was a great argument and bordered on inappropriate in terms of mitigation. It was worth it for the state to get that out, even if the objection was sustained. Thanks, because I was wondering if the defense had a legitimate argument, because it does seem, and I will tell you that I have observed a noticeable cooling of the judge toward the defense after it came out in voir dire yesterday with the shenanigans of the familial witness that had allegations of SA. It does seem like the judge was not appreciative of how they handled that. Maybe it didn't fully, go into sanctionable behavior, but it definitely wasn't fully on the up and up.
He doesn't somehow become a vegetarian. And that's exactly what we have here. Just because you cage this lethality doesn't mean it goes away. But hey, We wouldn't have predicted this. We wouldn't have predicted this, but you can trust us now. He won't do it again. I submit to you that the only option here is to prevent him from doing that permanently. Don't give him access to anyone else. Now, mitigation, there is nothing I can tell you.
Hang on, Mr. Staley. Sure, has to take a break. Go ahead, man. No, come on, everybody's gotta go.
And I think that the judge hasn't done or said anything in front of the jury, and it's only if you have been paying attention this entire trial and you're a very avid people watcher that you would notice, because it's very, very subtle. I will say that, but there has been a noticeable cooling and a less willingness. He lets the defense do their entire spiel. But sometimes he would ask follow-up questions. Lately, he's just been overruled, without any further comment on it. So take that for what you make of it, but it's noticeable to me. And we're gonna speed okay, come back.
All right, everyone may be seated. Mr. Staton, you may continue.
Judge, appreciate the break. I think we all appreciate the break, Judge. I don't have much more, ladies and gentlemen of the jury. When we stopped, I was talking about mitigation. In mitigation, we talk about the definition of it as something that reduces someone's moral blameworthiness. I don't know how there's anything possible in this case that reduces the moral blameworthiness of taking an innocent child, gratifying yourself on an innocent child, and then committing the kind of brutal murder that one committed. I can't see how there's anything that mitigates that reduces anybody's moral blameworthiness. But you know, this is what we get in capital murder cases. We get a capital murder diversion, is what I call it. It's basically you got somebody living their life, doing what they're doing, working, got a family, doing their best, succeeding, failing, buying a car, doing all those things, not being treated really for anything in their life, just working and doing what they're doing. But all of a sudden, they commit a horrific act. And the experts come out in droves to start explaining every single ailment that they possibly could have. And that's what happens in these cases. Nothing was going on in your life that caused you to have any issues before. You had a job, you were doing things normally, you were making some poor decisions. I mean, I submit to you that anything bad that is happening to Tanner Horn at that time is by his own doing. You know, you're not going to keep a job if you're out doing coke on the weekends and partying. You're not going to keep a job if you stay up all night and play video games. You're not going to keep a job or a relationship if you're doing acid on a regular basis. These are all things that are somebody's choices. They don't have anything to do with any disabilities or deficits that you have. So I think that, you know, to come here and to say, hey, now, I wouldn't really have any problems before, but now I want everybody to look at this. I don't think that makes sense. So remember what every single expert said, and we did ask him the same thing. One, did he know what he was doing? And every expert, including Dr. Brahms, the last expert we had up here, I asked her, did he know what he was doing when he kidnapped her? She wouldn't give me that when she subscribed to this catastrophe theory. But when it came to the sexual assault, she said, yeah, he knew absolutely what he was doing to her when he was doing it. And then when I asked her about killing her, He absolutely knew that what he was doing was going to cause her harm. Those are her words. That was the first question. And the second question we always ask is, did any of these conditions, any of these things, this litany of things that are out there, true or false, did they have anything to do with this? No. And that's what it comes back to. For all intents and purposes, Tanner Horner was driving a FedEx truck. And I believe he had fantasized about this. I believe this was something he had in his mind.
Council's opinions are not relevant.
Sustain, stay within the record.
The experts told you that he fantasized about things. He fantasized about what he wanted to be. He fantasized about being superhero. I think it's reasonable to believe that he planned this as well. This was something that was in his mind.
Objection, Your Honor.
Overruled.
Council's opinion is not relevant.
Overruled.
Like Dr. Arandula said, these things don't just spontaneously occur. And now you've heard some evidence of that. You heard some evidence of things that happened in the past, where he had done things in the past to victimize people. It never came out. You heard Billy come up here and struggle to talk about that. I think that's important, that he was able to come up here and tell you what happened to him. I think the two victims that came up here that were assaulted by Tanner Horner took a lot of bravery to come up here and talk to you about that. I think that's important. So all of that goes to say that there's no doubt that this was coming. We were just waiting on it. So when we talk about going to prison and serving life without parole, all we're doing is waiting on it to happen again. That's all we're doing. Now, all of Tanner's victims are in the same cage with him. Now he doesn't have to go find them. So I submit to you that the only proper verdict is one that prevents him from doing that. Now, we talk about structure and consistency. We talk about sameness. We talk about lack of change. Yeah, the Polunsky unit, Livingston, Texas.
Aaron, if you are expecting me to be appropriate and professional, I have bad news. No, I would rather you not. That is not this kind of channel. I wouldn't know what to do with that.
This has all of that. And what else it has is protection. It's protection for every single person who he might victimize in the future. That's the right place. That's the place where he needs to be. That's the place where there's consistency. That's the place where there's structure. That's the place where there's sameness and routine. Now, because of his actions, because of what he did at Athena, he has forfeited his right to sit around for the rest of his days, watch TV, play video games, hang out, go outside, see the sun on his face, have a job, walk around the prison like everybody else.
Okay, sir, if you go full Con Air and pull the famous line, now for today's movie, I'll never sleep with a woman again, and for today's food, I'll never have a steak again. If you throw that line in there, I will be your best friend. Now, I'm not going to come out to visit you. I will be more of a Zoom friend. And the monetary pecuniary value of said friendship is probably not, legally binding. I think it's priceless. I'm not sure that, actuaries would agree.
He has forfeited that right here, because of his own actions, not because of anything else, but because of what he did. What I'm going to end with here is this. Everybody's got things. Two things, actually. Everybody, we all have things that are mitigating in our life. The difference between us and him is we don't use that as an excuse. Now, the depth of what he caused, the level of evil, the level of pure blackness in one's heart. It's not only just Athena, it's her family, it's the community, it's all of us. And I think that we've all lived through this. I want to tell you just a short story about the level of pain, about the level of trauma that this has caused this family. A lot of you guys, I'm here, I'm the DA. You probably think I meet with people, I have to give them bad news sometimes, and I do. That's part of my job, but not like this. The story I'm going to tell you is the story of when I had to sit down with this family and I had to detail to them what exactly happened in this case. I had to sit down with them.
Your Honor, objection, this is outside the record.
Stay within the record.
And probably a good point from the defense. The state has been incredibly restrained and not kind of pulled on our heartstrings, and I've actually appreciated that. Um, that being said, I get the wanting to explain, but I think the jury is sharp enough to get it. I think that the jury is sharp enough to get it, and the state has been incredible at the use of the restrained and allowing the jury to understand the gravity with subtle, nods to emotional heartstrings. So I think it's not going to bother them. I think whatever the jury is imagining is just as horrific as it probably was, and I'm pretty sure that we're going to hear about it during the victim impact statements. So on that note, while I have a lot of you here, I do want to make sure that you guys are aware that there is a possibility that we will go directly from verdict to victim impact statements, depending on the time that we get the verdict back. But basically, because we already have the sentence and this is just the punishment, we might go directly into victim impact statements. And Aaron, long story, didn't graduate high school. You're great, Mo. Appreciate you and your authentic soul. I'll be in and out, got work to do. Everyone, thank you so much. I appreciate it. It's that whole sitting down and learning thing that I would have a problem with now.
Whenever you have these cases, families are very involved. Been here at all the court dates. You guys can see that. It's important that we consider all of this when we make our verdict. And the level of pain, the level of abuse that he has inflicted upon this little girl and this family are unfathomable. The level of lies, the multiple different versions of whatever truth it is, that video, everything you saw, it's important. Athena is important. Justice for her is important. And justice in this case has one result. I want to thank all of you for being here. Been away from your families, being away from your work. I appreciate your effort in this case. It's been a long month, and I'm going to wait your verdict. Thank you.
Up until this point, you have been unable to discuss this case amongst yourselves because the evidence had not been concluded. But that restriction is now lifted. Retired to your jury, begin your deliberations. If you need me, write me a note. I'll be right out here. All right? All rise.
It doesn't look like we've got anything in yet, but we
All right, we'll be in recess. Thank you.
are on verdict watch as of right now.
You did slow. You did have that already on.
So this is what we're looking at right now. Now, oddly enough, Court TV doesn't have the verdict counter, but they might be considering this lunch break. So they're going to start it after lunch. What I'm probably going to do, I am of two minds after those closings. Um, while I jokingly never put it past a jury because they are a wild animal of sorts, that they will come back with that 15-minute, like double deuces, screw you, middle fingers blazing to the defense. While I don't put that outside the realm of possibility, I see two more probabilistic outcomes. I see that we could possibly be getting a verdict by this evening, but I can also see that we might get a verdict by tomorrow afternoon. It is a very large task that we are asking these jurors to do. And unlike the defendant in this case, taking a life is a giant moral question, whether you feel that, the reciprocity is there and you're okay with it, or it's a deeply, hard kind of thing for you to justify morally. Howdy, howdy. So it will be interesting to see. While I don't give up on the possibility of a 15-minute verdict, I do think the quickest we will get a verdict, if we get one today, will be later into the evening, simply because these jurors have not been able to kind of have the cathartic release that we have all the time, almost instantly, because I'm streaming and I like to make fun of people. So they have not had that cathartic release. They might just need to hug each other and cry for 10 minutes or so, and then compose themselves and move on. So I do try to be mindful of the fact that they haven't had that catharsis, and there is time needed for that. You've got 12 people who have had to watch the most gross, horrible thing that they've ever heard. Um, and do that and weigh an intensely, ethically gray, morally ambiguous, depending on how you look at it, choice, a very dichotomous choice. What do you believe in? Where do you see this? So what I am probably going to do, since I got up fairly early, um, is that I will probably stop this stream and I will start another stream if we get any feedback that they're coming back. Um, but it has been rainy, it is yucky outside, and if there is anyone, oh, okay, it looks like according to the jury, there was a jury question. Where is the jury question? Are we going to come up to this? But there was a jury question, and it was about, the jury did ask for letters from Tanner to Chicken, and Chicken's letter to Tanner, along with a DNA report and all of the videos. So they've already picked a four-person, and it does look like they've asked more about, if you remember, Chicken is the prison buddy, so they wanna look at those, and then they want to look at the DNA reports. Now, the DNA reports, are the proof of the essay, so that is interesting. I will be paying attention to the live stream if, we get any other movement, uh, then I will pop back on live, but I honestly, if I were to have to rate out the possibilities and probabilities of what I believe is most likely in this reality, I would say that we're possibly and most likely looking at a verdict, in the morning, mid-morning to maybe around lunchtime tomorrow, just because it should be a grave choice. They should look at all of the evidence. Um Again, I don't know if, again, watching the videos will cement things, but at the end of the day, whichever way the jury votes, I want them to do it with all of the evidence, with giving them, a proper giving it the respect it deserves, going through the evidence, debating with each other, and then coming to a verdict. So I do hope that they are able to do that, but I foresee it maybe being tomorrow morning. Of course, now that I say that, as soon as I end this stream, as has happened in 2 other trials, within an hour, we will have a verdict. So I'm also ending the stream to maybe get a verdict before this afternoon. Um, but I'm going to find someone to send you to so that you guys can, enjoy the time on the tubes, while I take a little bit of a break, just in case we get a now I am going to research to see, how late court typically allows jurors to stay, because that will also be something that might dictate, their decisions. So I will be looking up that information as well. Okie dokie. I am sending you over to Broken Baker. He is doing the, Stefan Diggs trial. Now, apparently, he's a sports baller. But I will be back on if they come back with a question, if the live stream pops up anything, because I will be kind of over here editing videos and, doing some other stuff. And that could be it. Again, this is a grave decision. We are lucky that for a lot of us, having the power of someone's lives in our hands is a very grave, thoughtful, and terrifying decision. It's a good thing that most of us don't act with the impulsivity and irrational and just kind of disregard for human life that Tanner does. So I'm sending you over to Baker. I will be back on this afternoon if we get any particular information up. And also to possibly it has happened twice, here recently. As soon as I go off stream, something happens. So fingers crossed that Tanner or that Athena's family can, uh, get the justice that they deserve on Earth. And while there's no closure, while there's no words that will ever make this right, there will never be, a life that isn't after Athena. Um, I hope and pray that their lives continue to grow around that grief. And one day that grief isn't so large and isn't so hard to carry, because that's reality with grief, and I do hope that. I do hope that soon one day, um, the memories of Athena are not painful, they bring comfort, um, and I hope that they have the love and support they need on that journey. I will see you guys in a little bit. I am going to rest. Be safe, be kind, and have a good rest of your day. I will catch you if we have any forward movement. Bye, you guys.